Kind permission, serial number 16, further hearing matter. The on-record counsel, my lord, is in hospital, my lord. Next week, my lord. Yes, please, ma'am. Next week.
13/11, sir.
Serial number 25, my lord. Final hearing. Some inconvenience, my lord, personal inconvenience, my lord. 2 weeks time may be granted. my lord.
No, sir.
Inform the other side, my lord. Up. Great, my lord. Your lordship.
27 matter, but I'm for the appellants.
11/12.
It's 2 weeks. This request for 2 weeks, some inconvenience.
Your lordship.
The other side is my friend.
Serial number 26.
Lord, serial number
So, counsel for the appellants. I'm the appellant counsel.
12/12.
Please.
Your lordship, serial number 26. Synopsis is not filed. I inform the other side also. Kindly request for 2 weeks time. Next time we'll be ready with the IR.
Date may be fixed in mind.
Much of
16/12.
16.
My lord, moving the commercial appeal, which has been referred by this honorable court for mediation. The parties have reached an agreement as to the sum. The payment terms and the schedule are being discussed. The mediation ends on 11th. They have to send the file back to this honorable court. Hence, I'm filing a memo for posting, seeking for an extension. If it may be taken up tomorrow, we would request extension of time period of the mediation, my lord. There's a time period of 60 days. And any further extension, I have to seek from this honorable court. The file is in the mediation center, my lord. My lord, we would request for an additional 30 days.
My lords, only a copy. Only a copy is
Copy
being
is
sent to
being
the
sent.
center, my lords. The main file is with this court.
A copy of the entire file is sent there.
My lord, filing memo for posting for MFA, we challenged arbitration award. We challenged arbitration award in this court, my lord. And the respondent the respondent filed execution in trial court, my lord. Kindly have this matter on tomorrow.
My lords, moving a commercial,
12/11. 12/11, sir.
my lords,
my lords,
One.
moving, my lords, moving a commercial appeal matter, 2023 matter, my lord, no date has been given. In this matter, my lord, my suit got rejected under order 7 Rule 11. Any date after 15th, my lord.
14/11.
My lord, any date after 15th, my lord, kindly.
19/11, sir.
Lords, 2022 commercial appeal, my lords. The suit was dismissed on ground of limitation. Its appeal has been admitted, my lords, for final hearing. Any date subject to convenience of this court.
Yes, sir.
Please,
Yes.
please.
my lords, may I make a mention for adjournment, my lords? Serial number 22, my lords, kindly have it next week, my lords. I shall argue the matter in the coming week, my lords. Have some for personal inconvenience on this day, my lords.
No, sir.
Lords, kind leave, my lord.
13/12.
Obviously.
Lords, kind leave, my lord. Serial number 28, my lord. May pray for 10 days time, my lords. Serial number 28, my lord.
Mahesh. Sir, other side inform ಮಾಡಿದ್ದೀರಾ sir?
Have you informed the other side?
I'll inform, please, my lord. I'll inform, please, my lord.
Let the matter be called, Mr. Budial, just.
Please, my lord, please, my lord, please, my lord.
My lord, appellants have filed application under 39 rule 1 and 2 for the repair of building, my lord.
Ma'am, which matter she had mentioned?
MS.
Madam, serial number, madam?
22.
My lord, serial number 19, the counsel on record has travelled abroad, my lords. And she had moved the memo for not to post it since, however, the matter has been listed. Due to some family emergency, she had to travel to USA, my lords. 19, my lords, for the appellant, proxy counsel for the appellant.
The request for adjournment is made on behalf of the counsel for the appellant adjournment.
14/1/2025.
Obliged, my lords. Thank
Yes.
you.
What is the mentioning?
My lord, they have filed application under order 39 rule 1 and 2 for repair of the building, my lord. Kindly, it may be posted for tomorrow, my lord.
Is it a pending?
Yes, my lord.
MFA.
2015
Sir, MFA, arbitration.
division bench.
Arbitration, matra, sir. Only arbitration matters.
My lords, kindly, my lord, civil number 23, my lord. Seniors, there's some inconvenience today, my lord, if it may be taken up next week.
Wait, we'll see that. Just hold.
Please.
Number 1,
Ma'am, just.
serial number 1.
On the last date occasion also appellant was not present. It is adjourned to today, my lord.
Just pass over.
Serial number 2. Shri Manjunath BS.
Next time may be granted for file acknowledgement.
The objections be cleared within 4 weeks this term.
7/1/25. Serial number 3 is Suhas.
Let fresh notice be issued to respondent 2 to 4. Returnable on
7/1/25. Serial number 4.
The appellant has filed a memo for dispensation of notice to R3. He's a special land acquisition officer. He's an MSc arising out of arbitration proceedings under the National Highways Act. Once that is dispensed with, the matter itself can be hired for admission after notice. The appellant has filed a memo for seeking dispensation of notice to R3, who is none other than officer of the appellant. That is a special land acquisition officer of National Highways Authority of India. I have no objection for dispensing notice.
Appellants in this matter.
yes.
Your lordship. In the previous date, we had Your lordship, in the previous date, we had undertaken to deposit the enter before the execution court, your lordship. As per that, we have made the deposit.
You appear for 2?
Or 1 million.
No, that's the arbitrator, no?
Yeah, R2 million, I'm sorry, R2, contesting this.
Your
R2 million, respond number 2, I'm sorry.
Who has filed this for dispensing with the
The
respondent?
appellant has filed it to.
But why do you want to dispense with the presence of respondent number 3?
Your lordship, respondent number 3 is the
But he is the special land acquisition
Declaration
officer.
He
My lord,
comes,
he had passed an award, my lord. His award was challenged in the arbitration proceeding before
Your
the
Lordship, may I-
arbitrator.
the special land acquisition officer is the gazetted officer appointed from the National Highway under the state government, Your Lordship. However, to be considered, he is the part of National Highway. For the sake of brevity, I have made him as a party in this application.
So I'll let him be here. Why, what difficulty? The contesting party is two, no?
From the space, my lord, that's right. So what is happening is he is not being served and nor he is being represented. That is the
Who?
problem. Point number 3.
Okay, we'll service, no, he appears. No, you don't appear for, acha, you are not for deputy commissioner.
I'll appear for the deputy commissioner.
No, you don't appear for 3.
Usually what happens is that since the award is made and thereafter there is the arbitration, thereafter there is the
Yeah.
34. The land acquisition officer is not.
So we'll dispense with it.
I'd be obliged, my lord.
See, this is an IA filed by the,
Memo.
there is no IA, no?
Memo, my lord.
Memo, Your Lordship.
This is a memo filed by the appellant. Seeking dispensing with the notice to the respondent number 3. List of the counsels appearing for the respondents 1 and 2 agree with the prayer as made in the in the memo. Accordingly, notice to respondent number 3 is dispensed with. Memo is disposed of.
Well, may
This
make-
is in item 4.
Yes,
There is no 4.1, there is no this thing, no?
No, no, Your Lordship.
List the appeals for hearing on.
it may have to come for admission.
10, 12. For admission.
10, 12.
Much obliged.
Serial number 5.
In this case,
Serial number 5.
we have filed a memo for retirement, madam. Mr. Joshua Samuel has filed a memo for retirement.
But I have entered appearance in this.
Appellant has already entered appearance.
Previous learned counsel has filed a memo of retirement.
Just say this, who had filed the?
But Mr. Samuel has filed a memo of retirement. I have entered.
I appear for
Mr.
previous counsel. Joshua Samuel.
Okay. Just say that Mr. Joshua Hudson Samuel was filed a memo for retirement. He is allowed to retire as Mr. Venkatesh P. Dalwai, advocate, appears for the appellant and has filed his wakalat also?
Yes.
Wakalat. Full stop. The name of Mr. Venkatesh P. Dalwai would be shown in place of Joshua Hudson Samuel.
It should come up for admission anytime after 10 days, your lordship may kindly consider. 2022.
No.
Admission, it has to come for admission. Anytime, your lordship. So after 10 days, your lordship may kindly.
Just say list the appeal for hearing on.
11, 12.
Great.
Serial number 6, Shri Prakash.
Let fresh notice be issued to the
Process is paid today.
notice be issued to service on respondent number 1. Returnable on.
9/1/25.
Great.
Serial number 7, Pradeep Saukar.
Same order. Let fresh notice be issued to service on respondent number 4.
Please.
9/1/25.
Please.
Serial number 8, Shri Prakash.
Respondent number 2 is the only legal heir, my lords, to our knowledge. In filing that memo, my lords.
File an application, not like this.
Please, I'll file an application, my lords.
The learner counsel for the appellant states that he shall file an application bringing the LRs of the deceased respondent number 1.
The legal heir is already on record, my lords. Respondent number 2 is the only legal heir of respondent number 1. My lords, there is no other,
Just show us the memo.
please.
Please. There are other legal heirs.
No, my lords, to our knowledge, it is, she's the only LR
Then
respondent.
why do you say so?
Let's have.
You say both. Respondent is the only legal heir. You have the memo.
Please, please.
Read the third line. The undersigned also
Yes.
case leads to make necessary on bring to other.
Any other surviving legal heirs?
You don't know. See, you have to take a stand. Either he is the only one or there are others. You can't have both.
That's to our knowledge, she is the only legal heir.
You should have only said so. File your application. States that he shall file an application bringing the LRs of the deceased respondent number 1 on record.
Please.
Three
At his-
twelve,
At his request, re-notify on.
312. Serial number 9.
My lord, I have taken steps today, my lord. I have taken steps today. My lord,
Notice be issued to respondent number 1 to 3.
my lord, I also permitted to take standing counsel for HAL, my lord. All the respondents are HAL.
Additionally, comma, service shall be effected on the standing counsel for the respondent number 1.
Yes.
Line 125. Serial number 10. Mr. Nishant.
For the appellant in this case. Lords, we have filed application, my lords, for substituted service. That application is filed today morning, my lords.
What do you want?
Lords, the application has come to the court is what I
When
understand.
did you file it?
Today morning, we have filed
Did
it.
it come so fast? Has it come well?
In fact, my lords had directed us to serve on the learned counsel, my lords, who had represented the respondent number 1 before the RERA authority.
How many times you made an attempt to serve the respondent?
3 times.
What was the report of the registry?
Not that no such person was there or not traceable was the intimation that was received, my lords. But in fact, my lords are direct.
This is only in regard to one appeal.
All the appeals we have filed separate IS. There are totally 5 appeals.
What are the reports say? Well, this is the report. now.
First case. That is in first case.
What about the others? Just check up in all. See, is this business standard is in circulation there?
Yes, my lords. It is in circulation, my lords.
Where?
In Bombay, my lords.
No, we are in Churchgate.
It is, my lords. It is in circulation. We have verified and then we have filed this application. In fact, if my lords sees order dated 16/3/2023, my lords, we were directed to serve on the counsel who represented the respondent number 1 before the RERA authority. We have served them, my lords, through email, and the learned counsel has also acknowledged that he has received the copies.
Means What about five? What validity? That must be process fee. What about six? $10.4.
Okay, these are the same. Layer of five, six, seven.
Last two.
Last two, layer of five.
5 and 6.
Preparing 7 days. Can you keep this with them? 7 days. There are two.
They have not sought the execution also.
No, in fact, what had happened, my lords, there were totally 8 appeals, my lords. And in respect of other appeals, my lords, the appellate authority had set aside the order. The RERA appellate authority, my lords, has set aside it was a common order for 13 orders, my lords. That was a common order. Appellate authority said in respect of 8 appeals, it set aside the order and sent it back for fresh consideration before the authority. For these appeals, my lords, no order, they dismissed because we couldn't deposit the statutory deposit. Therefore, we are coming appeal before this court. In fact,
But are they not seeking execution?
no, my lords, no, my lords. Till date, there is no execution, and the other 6 cases are pending before the authority, my lords, the first court.
You are not concerned with those?
No execution, my lords, no execution as on date.
Just say this, you have filed in all the matters?
In all the matters.
Applications?
Yes, my lords, in all the.
You just say that the applications have been filed under Order 5 Rule 20(1) layer read with Section 151 CPC. With in all these appeals with identical prayer for effecting the substituted service on the respondent number 1.
1 minute.
Only one?
Only 1 minute.
Only one in the local newspaper. All are in Bombay?
All are in Bombay.
Business Standard as is widely circulated in Bombay city. The report insofar as the service report insofar as RERA Appeal 2, 3, 4 states, just show us that. Item 1. Unclaimed return to sender. Whereas the service report in respect of 5 and 6 states item returned validity period exceeded. Noting the report of the service report, we deem it appropriate to allow these applications permitting the petitioner to effect the substituted service on the respondent number 1 in all these appeals by way of a paper publication in local newspaper, namely Business Standard. Yeah, in the newspaper Business Standard as circulated in Bombay city. Returnable on
14/1/2025.
Good start. On such publication, the appellant shall file an affidavit of service enclosing therewith the copy of the publication. Publication at least 1 week before the next date of hearing. Applications disposed of.
Very grateful.
Say that. To be taken up on or before 11/20.
Serial number 11. Srimati Vanita.
Appearing for the appellants, my lord, we have filed this IA for recall of the order dated 31/7/24. On this particular day, the appeal came to be dismissed as the previous counsels had failed to comply with the office objections and on the said date had not made an appearance. We pray that the order may be recalled and be given an opportunity for us to be heard on the merits of the case, my lord. This particular suit, this particular appeal is connected with the three other matters, MFA 4809 along with 7 and 8 of 2016. And they are coming up for final hearing tomorrow before this honorable court. And if the order may be recalled, the appeal may be restored, we will argue on the same and conclude the hearings on this as well, my lord.
But what was the objection on IA?
My lord, we are not fully aware of what the office objections of the same are, as we do not have, since the suit was dismissed, we were not able to comply with the same.
Why did you file this application?
My lord, this application was filed by the previous counsels itself. By then, the clients have then brought us on, have taken our services and.
But unless and until those office objections are removed.
Yes, my lord.
How can we allow this?
My lord, we will comply within the due course.
In there for 6 years, it was not done.
Yes, my lord, and because of the same itself, they have changed the particular advocates, and now we will comply with the same email.
What is the objection on IA? You were only to file a second set.
Yes, my lord, we will do that immediately today itself.
First file it. Then we will look into it.
Much of it. If it may be posted for tomorrow, my lords, along with the other matters, we'll be grateful.
No, but now this becomes redundant unless this is filed. You file your second set.
Much of it. We will do it in the due course of today, my lord. It could be, if it could be posted with this.
By tomorrow?
My lords, it's connected with the three other matters, 4809, 8 and 7. It is posted for final hearing tomorrow. If it could be posted.
We'll have it tomorrow.
Yes, much.
File your second set.
We will do it immediately.
Or get it to the court. We'll take it on record.
Much. And learned friend may also be requested to serve me.
I know, let this, because today the appeal is not there.
Hello.
Once that we restore it, possibly you can come in.
Hello.
Next.
Serial number 12.
Okay, for the respondent. For the appellant. Last date of hearing, my lords orally directed me to find out whether the second respondent, authorized signatory, Mr. Nagbhushan, is the person who is going to be cross-examined before the who is the respondent number 2 herein, who is the party before commercial OS number 332 of 2023, which I have been, my lord, confronted the documents of exhibit D2, D3 and D4. Your lordship may kindly peruse my application dated 13 September 2024. I have stated, extracted paragraph number 4, my lord.
I state that the documents produced in commercial OS number 174, 2020, especially exhibit D2, D3 and D4, being the office of the notice dated 10/10/2017, postal receipt dated 11/10/17, and postal acknowledgement card dated 12/10/2017 are required to be produced before the Honorable Commercial Court in commercial number OS 332 of 23 filed against the first respondent herein. Commercial OS 332 of 23 is pending for evidence on the file on the Honorable 10th Additional District and Session Judge at Bangalore Commercial Court. Without the documents produced in commercial OS number 174, 2020, the respondent number 1 herein will not be able to defend his case in commercial number OS 332 of 20.
You are reading.
These three, my lord, paragraph number 4, my lord. IA dated IA 1 of 24, 13.
They don't update it.
13 September 24, my lord. I'm sorry. Paragraph number 4, my lord. Those documents are required to be produced before the Honorable Commercial Court in Commercial OS number 330 of 23 filed against the first respondent herein. Commercial OS 332 of 23 is pending for evidence on the file of the Honorable 10th Additional Decision Session Judge at Bangalore Commercial Court. Without the document produced in Commercial OS number
What do you
170.
say on this application?
Lord,
What do you say?
Lord, I don't have any objection to send back the, my lord, the record, but it has to be go back, my lord, the where the trial has taken place to that court. That is, my lord, 11th additional. But my lord, they are sought for, my lord, it has to be go for another court, my lord.
No, they say 11th additional. See the prayer.
Yes, my lord, but it was, my lord, the entire trial has taken before the, my lord, the 10th additional. Entire trial has taken concluded before the 10th additional. They sought for, my lord, it has to go before the 11th additional. If it is permissible, my lord, then I don't have any problem.
My lord, my application is, my lord, this matter is pertaining to 11th additional session judge matter, my lord. Those documents are required to be produced 10th additional district judge in OS commercial OS number 332 of 2023. This honorable court has taken the, my lord, reports from the my lord from the forensic. It has been my lord come back with a report.
Where is the trial going on?
Trial going on in the 10th Additional District and Session Judge at Bangalore.
They should be sent to 11.
That is
My lord, my lord, only it is pertaining to, my lord, I have stated in my application, send back the trial court records in commercial number to the additional 11th District and Commercial Court, Bangalore, my lord.
But we should say, it is pending in 10, now.
My lord, it is pending in that OS number, commercial OS number 332 of 23 is pending in 11th additional. But these commercial court, one are the same, my lord, branch. That record room branch is same, my lord. So that I will.
No.
My lord.
We don't know. See, these are all in, it may create more confusion. The file, to go at one place, it will go to different and people will start searching.
My lord, I have produced the certified copy, my lord, for confrontation before the second.
So rely on those certificates.
My lord, what my lord trial judge ask for original of the these documents are very much required for, my lord, to confront the signature of the original, my lord, to comparison of the because the report come back from the forensic report by this honorable court called for. Yes, my lord.
Which trial judge has asked you?
My lord, commercial OS number 332 of 23, my lord.
But you don't say so.
My lord, I
You
have
say
stated,
174 of 20.
my lord, I have stated in paragraph number 4, my lord.
See, what is your prayer?
Prayer, my lord, it is to register to send back the trial court records in commercial to the Honorable 11th Additional Decision dedicated Commercial Court, Bangalore Rural District.
And in which commercial original suit number 174?
Please, my lord.
But that's
This,
not
my
the
lord,
case.
this record pertaining to 11th additional, my lord. So that I should, my lord, only, my lord, request this honorable court to send back those for only purpose of confronting, my lord. Fix the date, my lord, to return back. One day, fix the date for, my lord, for confronting purpose. This records pertaining to 11th edition. Therefore, I have to ask for 11th edition only, man.
So are you seeking the file should go to 11th or 10th?
11th, my lord, 11th. So that I should file an, my lord, call for an application, my lord, request the court to call for the records of from 11th edition to 10th edition, same building, my lord. Therefore, I have to,
Question of same building, same room.
my lord.
It's a question of
My
the
lord.
record, judicial record will come from its original place where it is posted in custody.
My lord, my request, my lord, I request, my lord, I seek for 10th additional decision session judge at Bangalore, my lord, because for only for confronting purpose of those exhibits, my lord.
Which exhibits? In which
Exhibit,
matter?
my lord, D2, D3 and D4, that is the notice
In which
dated
matter? In which matter?
in commercial OS number 174 of 2020.
So that's pending in 11, na?
That's pending in the 11th additional decision, my lord.
See, this 11 has come to us. This 174, 2020 has come to us.
Please, man, it is coming from 11th additional, my lord. Therefore, I request to send back those records to 11th additional, my lord.
My lord, may I assist?
One niಮಿಷ, I will.
May I assist?
My lord, I will.
174 of 2022 has to go to the 10th additional.
174, 2002 for 11th additional.
332 is pending.
332 is pending in 10th additional.
Then why did you make this prayer?
My lord, because,
You see the prayer.
please, my lord.
So you should say, send the record of 174,
Please, my lord.
which is pending consideration of which record has been sent by 11th additional district session judge
Please.
to in suit number so and so, which is pending in 10th additional.
My lord, then my lord.
How it has to be couched.
My lord, I owe an apology, my lord. The
We will
intention.
not, we want an exact prayer here.
Please, my lord, I may be permitted to, my lord, amend my prayer.
The impression we are getting, it has to go to the 11. This has come from 11, we'll send it back.
My
But what is the use?
my lord,
Okay.
please, my lord, my apprehension, my lord, because the matter pertaining this records pertaining to 11th edition, that is why I pray, my lord.
But where will it go? You can still say.
Please,
so.
please, my lord, please.
Record pertains to this.
Please.
But it needs to go to this court,
Please, please,
this suit.
please.
Then we will send it.
Please, my lord, I request, my lord, kindly have it on Monday. Tomorrow itself, I will fill an application.
You withdraw this application.
My lord, I will amend the prayer.
No.
My lord,
Then a counsel for the respondent.
request, my lord. With liberty to file a fresh.
What? Which respondent?
My lord,
Respondent
respondent
number
number
one,
2, my lord.
Respondent number 1 is appearing.
Respondent number 1 seeks to withdraw this IA to enable the said respondent file a fresh application with better prayers. Okay? With appropriate prayers. Say like that. So file a better application with an appropriate prayer. Okay?
My lord, the difficulty is the honorable court asked that my request, it is urgent to this month, my lord. That is why I may be permitted to amend the prayer, my lord.
We will not allow that. It will lead to more confusion. Let's have a clear application here on record so that we can refer to the prayer also while passing an order.
I request to have it on Monday, my lord.
We will have it provided you
Please,
file
please.
an application.
Tomorrow itself, I will file out.
File it. Have it on Monday.
Monday. Great.
11, 12, 11.
Tuesday, just tell him Tuesday.
Sir, 12th.
Please, sir.
Tuesday.
Please.
Serial number 13.
Please, I will leave to inform.
Serial number 13, Sri Satish. 13.
Delay of 19 days. I leave it to this honorable court, my lord.
Who is for the appellant? Just pass over.
So 14, serial number 14. Shilpa Shah.
I appear for the appellant. Lord, I made my submissions on last date of hearing. None appeared for respondent number 1, who is the contesting party. Your lordship. Ask. Lord, hear me, Lord. Respondent number 1 is the landowner whose land was acquired, and respondent number 2 is a arbitrator, is a formal party. So on last date of hearing, respondent number 1 was not represented. Here, compensation was enhanced from rupees 34 rupees per square feet. That is 15 lakhs per acre to rupees 400 per square feet by arbitrator, citing that some other land, which was NA land, this was agriculture land. So NA land in residential layout, what is the rate? That is what awarded to the
How much
landowner.
arbitrator increased?
Sorry?
How much arbitrator enhanced?
From 34 rupees 40, like it's a 15 lakhs per acre comes to 34 rupees, 1 lakh, 15 lakhs per acre comes to 34 rupees, 34 paisa per square feet, which was enhanced to 400 rupees per square feet. So it was 12 times. And citing, though it was agricultural land, saying that land in nearby location, which is
Who appears
housing
for
board.
the respondents?
No one appeared on last date of hearing for respondent number 1. And respondent
Despite
number 2 is
service,
arbitrator, which is like formal party. It's just based on rule, like we have to.
you don't appear for R1.
For R1, no.
You appear for 2.
Please.
On last date of hearing, your lordship expressed that some judgment on section 3G7A.
Was the council present on that day?
No.
No,
We'll just pass over.
please, your lordship.
Do you have those judgments?
I looked for the judgments. I found few judgments. So one judgment is of single.
See,
Court of
ultimately,
Karnataka.
we have to see those, parameters laid down in
Yes.
3G7.
Yes,
In what manner the Supreme Court has interpreted it.
yes. So.
Surely, you may be right. If it is a finding which is a perverse finding without any basis, then it can be, obviously it can be. But we just wanted to know how, because we are in a special enactment.
Yes. So under, one judgment of Honorable Supreme Court, which I could find. So this is NHA versus P. Nagaraju and others. But in that case, what court has held that since right to fair is made now applicable, so section 26 of right to fair, section 26 and 28 of right to fair act to be seen. Like parameters, there are more parameters in the right to fair. So he said it is to be.
That is being talked in the context of 24(2) of the 2013 Act.
Yes. No, it may not be on 24(2), but this right to fair was made applicable for land according to NH Act only from 1st January 2015. So that judgment may not be relevant for our purpose.
We just wanted what is the, how 3G7 has been interpreted.
So all the judgments I tried, found
No, you're
on
right.
34, but not on 3G7.
We are not
3G7 I
concerned.
found, but of Rajasthan High Court and one of Chennai High Court,
On 3G7.
3G7. But there they say that we should, because here they say market value. So now we should go to Land Acquisition Act. But section 3J of,
But the market value need to be seen on the date of notification.
yes, that is there in the even Land Action Act.
But is it your case, this market value, what has been seen is for a subsequent period?
No.
It's on the date of
It is on the
notification?
date of notification.
Then what do you have to say then?
So that's why, my lord, I mean, my humble submission that this arbitral award requires to be set aside.
No, that's what we are asking. This 400 was on the date of notification, the rate per square feet, which has been enhanced.
There are two aspects. One, in my small submission, because arbitrator has not stated anything about that. When it was on which date.
Very right.
But when arbitrator passed award, he has taken that rate. So I presume that it must be of that date, which is subsequent date.
We don't know.
Yes, if we assume that we don't know. Now, second part is that rate and for that there is no doubt. Here we are not certain that which date. But second part, that this rate was for the rate market value of the layout, residential layout rate, which is NA led. This is agriculture led. So that also.
So no comparison.
No comparison. That is what my respectful submission.
Pass over.
Please.
In urgent, 16, Siddharth Suman.
Respondent.
The appellant. But this was a case where the plaint was returned by the commercial court under the premise that this is not a commercial dispute. Now, merely because the defendant therein, my lord, they had also filed a suit before the Mayor Hall Court. Now, my lord, this is a commercial premises, my lord, where I have taken this on lease. Now, the issue is that the landlord is now interfering with my possession. I file a suit for injunction, my lord, restraining them from interfering with my possession. Not back then in 2020 when the suit was filed. Now, the position was not too clear. But today the position is clear. This is something which is used exclusively in commercial.
Was being used,
my lord, because I was already doing my fit-out activities.
So why does he say it's not a commercial dispute?
My lord, merely because there was already another suit for injunction filed by by the defendant, that is my landlord, before Mayor Hall Court. So then the Honorable Commercial Court says, no, you go before Mayor Hall Court itself.
When was that suit filed?
That was filed subsequent to mine. Counter suit.
But how would that determine a commercial suit or not?
Lord, my respectful submission is this. There was a joint development agreement between the respondent and one builder by name Nitesh. My lord, this Nitesh Estates was supposed to complete the development and the power of attorney was executed by me, saying that once they complete, once the development is over, then they will be entitled to act upon the power of attorney and either create a lease or sell the property that is falling to their share. So there was in one of the addendums, the understanding was that once this particular portion is complete, then they will be entitled for 66% and I will be entitled for 34%. And whatever the commercial rate revenue that is generated, that will be shared. My lord, what happened was they never completed. They were supposed to complete the project in 2013. They never completed. 2016, I filed an arbitration application. Then the arbitration proceedings are held. Subsequently, an award is also passed, directing them to complete the development because neither the power of attorney comes into effect nor the project is deemed to be complete until then. My lord, in spite of that, they don't complete. They challenge the award. Section 34 application is dismissed. Now they have challenged it before this honorable court. That is pending. That is the developer. Now, while all these things are happening, in 2016, they create a lease deed. Even before completing the project, they create a lease deed. And they say they hold a power of attorney and execute it, saying that this will come into effect from 2020. And that lease is for 20 years. Without even registering it, without even paying the proper stamp duty, they try to take possession of the property. And they also file an injunction suit saying that I am interfering. I file another suit saying that this is what the circumstance is and they cannot interfere with my possession. And that is what the learned judge.
One thing.
Well, my respectful submission is this. There is no commercial dispute for this reason because I have not even entered into a lease deed with them. There is no question of dispute having arisen, let alone commercial dispute.
Tell us, no, he is not in possession.
He is not in possession.
My lord.
He is
Fit-out
not
act
in
of
possession.
case,
My lord,
photographs as well.
my lord, an injunction order was passed in my favor. They challenged it before this honorable court.
Now today,
In an
my lord, we
appeal-
are at a situation where there is
My lord,
status quo. my
in
lord.
an appeal, they challenged it.
Like this. Suppose they are, let's assume no lease deed.
Yes,
They are physically in possession.
they are not.
That's, no, we are just only
Yes,
putting to you.
yes.
Subject matter of right.
If they are in possession, which you want to recover, or he wants to proceed against you
Yes.
for whatever reasons, for all purposes, you are the lessor to him. You want to seek, or he wants to approach, or he wants to seek a remedy against you. Where would be the remedy with regard to the subject matter of the suit? That would be because it's being used for commercial purpose.
Please.
My lord, my respectful submission is this. Even according to the agreement, the lease comes into effect only in 2020.
It's a
That
fit-out
2000,
period.
that date has not come. Even before that, they filed the suit. That date has not at all come.
Was he in possession?
It
He
is
was
a-
not in possession. That is what he claims.
I was
No,
undergoing. my lord,
let me make my submission, my lord. My lord.
When I was
My
making
lord,
submission.
he was not in possession.
What really would matter is in
Please.
view of Supreme Court judgment, you should be in possession
Please,
to
please.
invoke this,
Please, my lord.
to invoke the provisions of the Commercial Courts Act, more specifically, the dispute, to say that dispute is a commercial dispute.
Please, my lord. In fact, this was also
He was,
dealt
he
with,
was not in possession, my lord, my respectful.
May I just
There was an
pass on-
injunction granted against him and they file an appeal.
That will be material.
May I
No,
just pass
they
on-
filed an appeal before this honorable.
Where is the finding of fact that he?
My
is not
lord,
in
may
possession?
kindly turn to
finding
page,
of
in
fact.
page 25. My lord, may kindly turn to in page 25. Lord, the paragraph 8. On the other hand, it is the submission of the learned advocate for defendant that in fact, the dispute of this case is not commercial dispute. Defendant has not executed alleged lease deed. Even the alleged lease deed commences from 1/4/2020. In fact, defendant being owner of the property had entered into joint development agreement with Messrs. Nisesh Housing Developers Private Limited and certain terms and conditions. Defendant had executed general power of attorney of the said developer. Subsequently, sharing agreement and also an addendum to the sharing agreement capturing the details of the sanction of construction were entered into. As per the terms of JDA and also a general power of attorney, developer shall not be entitled to possession and to transfer its proportionate share in the property until delivery of the owner's constructed area. It is alleged by the plaintiff that alleged lease deed was executed on 1/1/2016. In fact, on 1/1/2016, developer did not complete the project as per the terms of JDA and as such, developer had no right to execute the lease deed in favor of the plaintiff. Therefore, alleged lease deed is void and not binding upon the
Has
defendant.
executed the lease deed?
That is the developer. Developer is not even arrayed as party.
You did not execute.
I did not execute.
But as the GPA
They,
holder
no,
of
they
them-
claim that I have executed as GPA holder. They rely, and they also claim that they have made a payment which is not even, which has not even reached me.
Very well.
Till today, they have not been able to.
The developer has executed the lease deed, has a power of attorney of yours.
That is what their claim is. My respectful submission that it is a setup document. It is.
Where is the averment or a finding or a case set up that property is being used?
May I just take my lords to the plaint? my lord?
How do we get that?
I have, my lords may kindly come to the plaint. Plaint is at ink page 660, my lord, 63. I have already started the fit-out activities. 2018, 2020 is where the fit-out activities, my lord, because I cannot just take the property threadbare. It'll have to be, I have to, because my lord, I am into short-term storage plans. So it can be commercial, it can be private. Now, insofar as I have a very specific plea to say that I'm in possession of the property. I've started fit out activities as
What
well.
is the commercial nature of the property?
It is a commercial, this is a commercial block itself, my lord. It is made for commercial purposes.
Where do you say you are,
My lords may kindly come to.
based on the lease deed executed by the
Please,
developer?
please, please.
You are holding on to that property?
Please, my lord, please. I've made, my
Then
lords
tell
may
us one
kindly
thing.
come to 65. my
Didn't
lord.
you make the developer a party?
My lord, there was no interference from their side at all, my lord. It was only the landlord who was creating a problem.
What
It
is
is a suit
this?
for injunction.
You may not seek a prayer against a defendant.
Please. My lord,
Surely,
I have
as a
gone there.
proper party, surely you will make him.
My lord, if need be, I'll make them a party. That's absolutely no problem at all.
Now,
But there was only
where is the
interference.
finding you are holding on to the property?
There is no finding at all, my lord. There's no finding at all to that extent.
Where
The
is
only
your-
find.
Where is the case set up by you?
My lords may kindly come to 65, my lord. Page 65. Thus, for a period of 548 days, starting from 1/10/2018 to 1/4/2020, the plaintiff has been put in possession of the scheduled property in the said period, treated as fit-out period, during which period the plaintiff is entitled to carry out fit-out works activities in the scheduled premises, and during this period, the plaintiff is not liable for any rent. Then, my lords may kindly come to the next page, my lord, page 7. I'm sorry, page 66, paragraph 7. Plaintiff submits then as of this date, the plaintiff has invested about 2.7 crores in the scheduled property for storage room, lockers, electrical cable, panel board,
Tell
computer
us one
software.
thing Then, if that be so, it is being used for commercial purpose. Then will not be construed as a commercial dispute.
Lord, my respectful submission is this. The property is not in their possession in the first place because.
We don't know, these
Because-
are the averments.
No, because, my lord, that's why, my lord, I have filed a detailed written statement. In fact, it is my specific case before that is
Have
what
you
the learned
seen
trial
the
judge has.
Judgment?
My lord, I have, in fact, I've produced another judgment also of the Karnataka High Court coordinate bench.
My lord, in
with
fact, I
reference to
have an
all that.
injunction in my favor. In fact, as against that injunction, they file an appeal before this honorable court.
Injunction against what?
With respect to the very same property,
Property.
On what?
on the ground that they cannot interfere based on this lease deed
No,
with my possession.
that is the suit which is filed in Mayor Hall, my lord. Now, my lord, both the suits are now before
My
Mayor
lord-
Hall.
But you would not determine, your suit would not determine.
No,
his
it
remedy
is not.
If it is otherwise maintainable.
My lord, that's the finding. My lord, this honorable court has given a finding insofar as that suit is concerned, my lord, where I had, where they challenged the order passed by the trial court.
Yes.
My lord, may kindly turn to.
Where is that Supreme Court judgment?
My lord, it's referred to in the judgment which I passed on, my lord. In fact, this in detail, my lord, it's referred to. If my lords may kindly come to
Yes,
paragraph.
where is the relevant part?
My lords may kindly come to page 11, paragraph 13. In fact, the relevant portion may come in page 14 and 15, my lord. Immovable property used exclusively in trade, that's highlighted also, my lord. It's in bold. If the submission on behalf of the original plaintiff is accepted that it is the case, it would be adding something in the statute.
Used must mean actually used or being used.
Please, my lord. And my lords, this is also a very similar case where it was a lease deed itself which was executed. That was a commercial premises. There was a breach of the contract.
We have not understood this, that you have filed a suit,
Yes, my lord.
a normal suit, not a commercial suit.
Yes.
To determine his remedy.
No, not to interfere. No, my lord, not to interfere with my possession based on
Take
this
it, you
lease
have
because.
filed it. We say nothing on that.
Yes.
But can that be a ground to dismiss his whether when it is a commercial dispute?
No, there is no commercial dispute for this reason, my lord. My lord, my respectful submission is the Honorable Supreme Court has said he must be using it for commercial purpose. There is no usage. He has not even been put in possession. When we talk about possession, we are referring to lawful possession, my lord. My respectful submission is he just, my lord, my respectful submission is this. This is what we have contended in the written statement also, that the appellant before my lord is the same. It's another company. It's a group of companies belonging to the same developer only for the purpose of getting over the arbitral award that is passed, that is the arbitration proceedings that is going on. They have created this lease deed, and so that they can create multiplicity of proceedings, interfere with my possession. They have forcibly taken over, they have tried to take over possession based on an injunction. In fact, when I get an injunction, they come before this honorable court, suppress facts, and they get an order of stay, and then they go and try to break open the lock. That is what the finding of this honorable court is in the appeal order that I have passed on. Well, factually, they are not even in possession. They cannot use it for commercial purpose. My lord, in fact, the premises is under lock and key, and the keys are before this honorable court, before the registry of this honorable court.
That, my lord, that's the position today, my lord. I'm not disputing.
They
But
can't
as of
say
the
that.
date of filing the suit, I have produced, if my lords were to
My
kindly
lord,
come
it is
to Annexure E.
necessary that
Annexure E, my lords may kindly come, my lord. Annexure E, page 59, I produce all the photographs, my lord. This is inside the commercial premises. Now, whether it is lawful or not, I am still in possession.
my lord, that's the subject matter of the other MFA, my lord. That is where this honorable court has come to a conclusion that the keys have to be placed before this honorable court. It has to be proved in that case, in the trial, in OS number 26182 before Mayo Hall.
But tell us one thing, when would the lease commences?
2020, my lord. 2020, but then, my lord,
Did you file the suit?
my lord, I filed it in 2020 itself. But here, my lord, the
No,
fit-out act-
2019, my lord.
Before
when
it
it was,
commences-
when it was in 2019, I'm sorry.
Before it commences.
Please, my lord, because I
So
was in the
were you
fit-out.
Were you in possession of the
I
lease
was,
property?
I was.
How?
My lords may kindly see the lease deed itself. I have also made an averment to that extent because fit-out activities have to commence prior to that. So the period of 2018 to 2020 is treated as a fit-out period, where I'll have to come and fix all my articles, my lord. That is where, because that is a rent-free period, my lord. I cannot pay rent that time. And my lords may kindly see, my lord,
That may not be construed as being used for commercial purpose.
it is still, my lord, it is still, I'm in
You
possession
may
at
have a
least.
constructive possession, we don't know. So
Please.
The requirement is being used.
Please, I do understand.
That's the requirement.
May I just take my lords to the judgment also, my lord, because the Honorable Supreme Court's judgment is also discussed in this judgment. And it's a very similar case. There was a breach in terms, my lord, this is a breach insofar as I'm concerned, because a breach insofar as the terms of the lease deed, because I'm not able to enjoy the fruits of I've paid.
So one, that's me. If you are not able to enjoy, that means
Please.
you are not in physical possession.
I am, my lord. Being able to enjoy is a separate aspect, my lord. To be in peaceful possession is one, to be in possession is another aspect. I am in possession, but I'm not in peaceful possession, which is why I come before this honorable court, rather before the honorable commercial court. I have produced all of these documents. Now, my lord, there is no dispute that all of this, that is, these lockers have been installed in the very same premises. There is no dispute. My learned friend only says that this is illegally put in there. What is there? 2.7 crores I've invested
So
in
what
2000.
has been permitted, it appears is,
Please.
the lease would commence from that day. In the interim, we will permit you to put your
Please, fit out activities, because
fit-outs.
without my
That's
fit outs, I have no possession, my lord.
No, that may be a different district, but it would still commence at a future date.
That is the lease, my lord. That is where I have to, so lease.
Seriously, you are not understanding what is the intent of that provision under the.
My lord, then we'll
See
just
the-
read
see
the
the
provision.
provision.
We'll just
See
read
the
the provision, my
provision.
lord, please. My lords may kindly come to page 37, 3.2. The payment of lease rent shall commence. Now, this is only for payment of lease rent, my lord. It is not for anything else. The period of 48 days, starting from one.
Agreement relating to immovable property used exclusively in trade or commerce.
Please, now this is a commercial block itself. It is a commercial block, there is no dispute.
It may be.
Please, my lord.
But are you using it?
I am using it, my lord.
Very well.
My lords may kindly see 3.2. 3.2 of the lease deed, my lord. My lords, I produced the lease deed, page 37. A period of 548 days starting from 1st October 2018.
70.
My lord, 37, 3.2, page 37. Please. Now, my lord, in fact, 34 itself, as the lessee intends to share, 34, if my lords were to kindly come to clause 1, as the lessee intends to share the commercial space to be let out by the lessors in common, the lessors have granted. So it's a commercial space to begin with. Then my lords may kindly come to page 37. 3.2
Read it.
shall be regarded as a period of 548 days starting
Why
from
don't you
first.
read the earlier sentence?
I'm sorry, my lord. The payment of lease shall commence from the expiry of the fit-out period as defined. So
What
that
does
is
that mean?
insofar as payment is concerned, my lord.
Obviously, the lease commences from a future date.
It is, my lord. So lease insofar as my payment is concerned, because
Obviously, how can you use it for an
my lord,
earlier
at
period?
least,
It is only for the fit-out period.
may I just make one submission, my lord. Now, insofar as any commercial premises is concerned, my lord, I have to first have, it's usually here, it's at least
We
about 2 hours.
are within the jurisdiction of, we are interpreting provisions of a commercial act.
I do understand.
That's
I do
right.
Please.
Whatever is see, the issue is only your right to forego or your right to agitate before a civil court is not taken away.
Please.
The only issue is jurisdiction of a civil court.
Please, please.
There is a particular provision which
Please.
contemplates only under this eventuality, it will be construed as a commercial dispute.
Please.
That means the property is being actually used for that.
Please.
Mere a fit-out period as different from a lease period
Please.
cannot be construed as a being used. It is for the purpose of enabling you to put the fit-outs.
I do understand, my lord.
So-
But then, my lord, to at least interpret what is being used, my lord. Again, my lords may correct me if I'm wrong.
What we say, look at the
Please.
Supreme Court judgment.
Because the Supreme Court judgment itself, my lord. So being used itself, let us assume for the sake of argument, my lord, I was put in
Likely to
possession.
be used, even the Supreme Court says so.
Please. Likely to be used is something which is contemplated in the future where, let's say, my lord, there was no building at all. And then a building is going to come up.
Come to-
Thereafter, I'm put in possession.
Come to page 7 of that. Okay. Now come to
Please, my lord. If I was in a situation pre the execution of the lease deed, my lord, I would have to bow down saying that, yes, it is pre that. I have already entered into the lease deed. I have already been permitted to do certain activities. Now, whether those activities are construed as it being literally used, my lord, it is being literally used because I am already fitting out all of
to
this.
page 14 of this judgment.
Please, my lord.
Now, just come to the 7th or 8th line from the bottom.
Please, my lord.
The bold portion,
Please.
immovable property used exclusively in trade or commerce.
Please. Now that we are,
If the submission on behalf of the original plaintiff is accepted in that case, it would mean adding something in the statute which is not there in the statute, which is not permissible. On plain reading of the relevant clause, it is clear that expression used must be actually used or being used.
please, my lord. And that's exactly what I'm doing, my lord,
Being-
because even if I'm not paying any rentals to him as yet, I'm already using that property, my lord, to put my lockers in.
What is contemplated under the lease deed is from the date when the fit out period is over,
Please,
on a particular date, the
Please.
lease would commence.
please,
If the lease would commence, you are not using that commercial property in the manner contemplated under the lease deed. That
I
would
don't
commence on that particular date.
I do understand, my lord. Now, my lord, it is his contention that I was illegally put in possession. Now, my lord, then I am in possession nonetheless. Let's assume that it is not by virtue of the lease deed at all. Then what happens, my lord? It is still a commercial premises. I am still in possession. I am still using it for whatever purposes. Let's say, my lord, albeit illegally itself. Let us assume it is illegal. I am still in possession using it. Then what happens, my lord? Can
Using
my
for-
possession be
Using for commercial purpose.
for commercial purposes? Because then, my lord, I'm sitting there. Let's assume I'm sitting illegally there.
But you are still using for commercial
For
purpose.
commercial purposes.
Let's
my lord.
assume you are selling something,
Please,
even though illegally.
yes, my lord.
Let's assume
Please.
you are being used, possibly you can argue.
Please,
But in this case,
please.
you are not commercially started your venture there.
My lord, I've already started advertising, my lord. I've already started everything.
Not what is contemplated.
Please.
That's not contemplated. Contemplated is actually physically is using it for commercial purpose. That's the intent.
I am physically there with my lockers there, my lord. It is not, my
What is
lord,
there?
my lockers are there, my lord.
Will that suffice?
My lord, that is
What is
me
the
utilizing.
nature of commercial activity you undertake?
My lord, so this is where I provide lockers, my lord, locker facilities for commercial premises,
Right.
for private usages.
Effectively, it would be construed to mean from that particular date, you will start selling the lockers. That's the day when it
I
was
rent it out.
fixed.
Please, I rent it out.
That's the intent.
Please.
We can't rewrite everything. That's the intent. That's what Supreme Court interfered. Likely to be used, maybe during fit out period, it is likely to be used from that particular date, which is fixed under the lease deed.
Please.
That's right.
may I then, my lord, may I just make one submission? May I then, because I had also gone through a similar proposition. May I just do a little more research? I'll get something on fit out activities
Do
itself.
that. We
On
don't
fit out
want to.
activities itself, I'll get it, my lord.
Maybe
Because
we may
if
not be
fit out
correct.
activities itself, I can at least may not be in this interpretation, but if fit out activities, I can say that this is me at least being in possession, be it constructive or otherwise. Then, my lord, then I think, my lord, then I can make out a case.
We don't say anything on
Please,
that.
then I'll do that, my lord.
Intent is to use that premises for commercial purpose.
Please.
Merely because you have a possession, constructive possession or an actual possession,
Please.
or you are undertaking work for fit out,
Please,
would that construe as an actual use is the issue.
please, my lord. I'll just see whether fit out activities, my lord, because in essence, my lord, it's like a license.
Then why did you agree for a further date, a future date?
I'm sorry, my lord.
Why did you agree for a future date?
Future date was, my lord, because anything in commercial, today, my lord, in commercial
tell you why.
parlance itself, please.
So that your liability for fit out period to pay the lease amount is not there.
Please, and that is, my lord, an understood thing, because I'm
That's
also,
the intent to exclude.
but my lord, I'm also paying a security deposit. No, that is already paid. It is not that I have to pay it later. I've already paid it.
Securities concept is different.
My lord, but then it
But at a
starts.
lease
that
amount
is
is
where,
different.
that is where it starts, my lord, because I pay the security there.
Request of counsel for the appellant to look into the law on the issue which arises for consideration re-notice. Look into it.
I'll do it, my lord.
See the intent of the.
Please, please. Because the security deposit also, my lord, just at least this is more academic than anything else. If I pay the security deposit in 2018 itself, when the lease is already executed, my lord, that is when I start the entire premise. It's just that, my lord, that one period is excluded for me not to parents.
Then why did you say fit out? You
It's a
should have
fit out
said
period.
lease period commences.
My lord, fit out period is, this is at least in commercial parlance, my lord, this is the language which is used.
We don't know. Surely
Please.
the lease period and fit out period are two different exclusive.
It is, and so far as at least the lease deed is concerned. Please, my lord, I'll just do some research and come on.
Lord, another aspect is that the developer, they have not made the developer as a party. The reason is, my lord, the developer and this particular appellant, they are the same group of companies.
They're not.
In fact, they are, my lord,
Very well.
the directors are saying, it is only for the, there is an award passed against them, against the developer to complete. As on today, even today, it is not complete. The project is not complete. There is no delivery of possession in favor of the developer himself. Then where is the question of him delivering possession to his lessee? This is something that that is what.
We are not saying anything. We are
Yes.
only considering the judgment of the court below, saying that this is not a commercial dispute. We are only testing that proposition.
Please.
That's all. And he has to satisfy.
Whether fit out would
In
come into
fact,
the
my
picture.
learned friend submitted that
actually being
the
used.
suit was filed in 2020. The suit was filed on 30/8/2019. There is a order sheet produced by my learned friend himself at page 80, ink page 80. Even before the actual commencement.
But
And
the-
in his
the-
own
the-
plaint, he says that payment was also done to Nitesh developers. It is not done to me.
Did the Supreme Court judgment referred by the learned judge?
No, my lord. My lord, back then, let me be honest,
Did not go on that
2020,
issue. He did
it was
not go.
quite, he only says that as per section 2 subclause, I'm sorry, as per section 2 subclause 7, it doesn't come within that purview to say that it is a commercial premises or that it's being used for commercial, exclusive in trade and commerce. So that is the only finding, my lord, nothing else.
No, the finding may be correct,
Please,
but what is the reasoning to come to that
nothing,
finding?
my lord. They only say that there's already a suit pending in Mayor Hall. Because
That's no
the suit,
reasoning.
that is
That's
it.
we are
No,
very
no,
clear.
no, no,
Anything.
no, no, not only that, Lord, it is a considered order. my lord.
We will show you.
It's-
Come to para 13.
Yes.
I'm sorry, come to paragraph
13 and 14 has it.
That's right. 14. After nature of the plea involved, the nature dispute suit does not come within the purview of the, therefore this court has no, to try the suit along with, is basically going on that particular suit which is pending before the,
And which is
No,
subsequent
no,
to my.
my lord, that is one of the, it's one of the observations, my lord. In fact, that is why I started reading from paragraph 8, where my submissions are also considered, my lord.
he should have gone into the issue whether this being used as a commercial or not. That's the focal point. That need
My
to
lord,
be
the fact remains that it was not being used. The fact is that, my lord, I
Let's
have
be-
passed
let's
on
be
the
very-
judgment.
Possibly what he is arguing is possession, he's saying in the sense that it is being used for, he is putting his fit outs, hence he has possession. But that possession would be construed as a possession what is contemplated under the lease deed.
What he is claiming as possession has not been recognized by this honorable court in the appeal that he has filed.
That's what we have put it to him, let him
Yes,
look into it.
yes, ma'am.
Please, just give a date.
That's the order that I have shared.
Whether that would be actually a possession or not, what is contemplated for the purpose of commercial courts.
Very well.
26/11.
May I request first week of December, 6/12, if possible, 6/12 one more, before this bench, there are two more matters. 6/12 if possible, before this bench, I have two more matters, my lord, on that
No,
same day.
just see, we, whatever is convenient.
If
give that.
that's, okay.
What is convenient, give that.
Sir, 4/12.
Yeah.
6 possible. 6 possible.
4/12.
If 6
Alright.
is possible, if 6th is, because see, I have two more
Want
matters before
6th?
this honorable
You
bench.
want
itself.
6th?
Please, if possible,
6.
6th of December.
please.
6th of December.
Please, grateful.
17, Vivek Kolla.
The respondent's appeal. An interim award was passed, my lords. Challenging that, my lord, section 84, section 34 was filed before the learned commercial court. That came to be dismissed. Challenging that order of section 34, my lord, section 37 is preferred before my lords. My lord, during the pendency of this matter, my lords, a final award has also been passed.
Who appears for? You appear for whom?
For the appellant in this matter, my lords. Served and there's, this shown as served.
No, but tell us one thing.
My lords,
You are
I take, otherwise I will take notice on the counsel who is appearing in the connected appeals, my lords. When Mr. Nishal Dev appears,
So your 34 has been rejected.
please, my lords, against the interim arbitral award.
Against an
Interim arbitral award, my lords.
under which 17?
Please, my lord. No, not under section. It's
Otherwise, as an interim award. only.
Please, my lords, not interim order, it's an interim award.
Interim award.
Please, my lords. That's been challenged before section 34. That, my lord, during the pendency of the petition, my lords, there's a settlement took place. The matter was referred before the mediator, Honorable Justice R.V. Ravindran. An agreement was filed. Now, regarding that agreement, my lord, that settlement agreement, the arguments were going on before the coordinated bench, my lords. In this matter, my lords, if the matter may be deferred to
Who is the other side?
Mr. Nishal Dev, my lords, I may permitted to take notice on him, my lords.
Has you been served, ma'am?
Served on the respondent one, but not been represented by the council, my lords.
Okay. But this is a different award.
Please, my lords.
These are
It's an award by the same arbitrator, by the same learned arbitrator, my lords.
By the learner.
Please, my lord. Regarding the very same subject matter.
None for the respondent. Is dispensed with the service on R2.
R2, my lords, the learned sole arbitrator, my lords. Please.
Say none for the, just wait, I think they may come. Let's see.
Because only his name is not been mentioned here, my lords.
What is the name of the council?
Nishal Dev. Mr. Nishal Dev, my lord.
Okay.
Please.
Just say that there is no representation for R1. Full stop. The name of Mr. Nishal De, who has filed wakalat, ma'am, has he filed wakalat?
I don't think so, my lords. I may be permitted to serve a copy on in my lords.
Then how would you say he is appearing?
Or
Nishal
in the
De.
in the connected appeals, my lords, for the respondent number 1.
Just say that none for the respondent number 1 despite service. Just say this. Full stop. Re-notify on.
3/12. 3/12, sir.
Much obliged.
Serial number 18.
Lord, I am appearing for respondent in this matter.
Lord, I'm for the appellant insurance company, below. So the award asked by the arbitrator has been set aside by the commercial court on the important 2 grounds. That is, let me take into, just briefly, I will mention.
You are ready now? You're ready for arguments?
I mean, some more preparation is required. Suddenly it has
No,
come.
we'll just pass over, we'll just look into it, we'll just pass.
But may I submit my otherwise, my lord? This could be taken for hearing itself, but rather than for admission for this reason. My lord, the respondent is in a very dire situation where, my lord, neither the money was paid for repairing of the aircraft.
Counsel, ma'am.
That is why, my lord, could it be taken anywhere, any day next week, so that, my lord, it can be taken up for hearing
The
itself.
counsel for the parties to file their written submissions along with the judgment they want to rely. Within 4 weeks this term.
Yes.
17-12. 17-12.
I reply.
17-12, sir.
Much.
19 Arjun. 20 Shri B.M. Siddhappa. 20.
I'm appearing for the appellant, my lords.
Yes.
Yes, in this connected matter, commercial appeal 80 of 2022 has been filed before this court by rejecting the IA number 2, and allowing the IA number 3. By rejecting the IA number, dismissing the IA number 3 under section 8 of the Arbitration and Conciliation Act, my lords. IA number 2 has been filed by the plaintiff under Order 39, Rule 1 and 2 of CPC, has been rejected. Before the trial court.
You appear for the respondent?
Please. Again, section.
But tell us one thing, there is an arbitration clause. No?
Please, my lord. We are.
In the, this arises from a partnership?
So, a loan agreement, please.
Loan agreement.
And
So once there is a arbitration clause,
please.
how can 8 be rejected?
No, it was allowed, please, my lord. It was allowed.
You see this?
The 39 rule 1 and 2 my lord, was rejected. And section 8 application came to be allowed.
Was allowed, refer
Please.
to arbitration.
Please. That is.
Now, what is the proceedings today? As the arbitrator reference has been made, arbitrator taken over?
Not yet, please. That was the
Yes,
appellant-
ma'am, what do you say?
Lordship, in the grounds also we had mentioned that the plaintiff has been filed a suit for mandatory injunction for the redemption of the account against the defendant. The defendant is flexibly, he is paying the every month loan recovery amount. As so without
Just 1 minute. Come to page
at the time of the COVID-19, entire country was suffering for the COVID-19. At that time, they had demanded more rate of interest.
Just 1 minute, ma'am, just 1 minute. Come to page 20. As barred under section 8.
Please.
He says suit is as barred under 8.
Please. Order to be returned.
Yes.
Plaintiff is returned.
The suit is barred
Please.
because of 8.
Please.
Yes, ma'am, tell us what is wrong in this order. Just pass over, I think, this caller, pass over.
Please.
21 Shivekula.
In this matter, my lords, the respondents appeal, my lords, by section 8 under the Arbitration and Conciliation Act came to be rejected on the ground that I did not have the right to file the written statement. My right of filing the written statement was forfeited since I did not file the written statement within 120 days of the filing, getting the summons, my lords. In this matter, my lord, the suit was filed during the COVID period, my lords. During the COVID period, in April 2021, the suit was filed, my lords. Till from 1st of April 2021.
When were you served?
That was served during the COVID period, my lord, in the interim of the COVID period only. I submitted my written statement in March 2022. Section 8, before filing my written statement.
No, that would not help you.
Please, my lord.
Section 8, pendency of section 8 would not help you.
No. I filed my application under section 8 that was rejected.
And
My
then
lords,
you file your written statement.
I did not file, my lords. Challenging that order, my lords, I have come before my lords, my
You
lords.
have challenged section 8.
Please, my lords. Rejection of section 8, my lords.
So we are not concerned with written statement.
Please, my lords.
Now, what is the ground for rejecting section 8?
Kindly, my lords, kindly come to page 21 is the operative portion of the order, my lords. May I read it, my lords? Defendants Counsel filed application under section 8 of the Arbitration Conciliation Act along with copy of service agreement dated 1/6/2019, copy of the application furnished learned counsel for the plaintiff. Various provisions for section 8 of the Arbitration Conciliation Act and same is extracted here for the convenience. I will skip over that this one, my lords. The provision of section 8, may I read it, my lords? Power of refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless he finds that prima facie no valid arbitration exists. As per this provision, if a party to the arbitration agreement or anybody claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute, if such an application is filed, then the court is required to refer the parties to arbitration. Whereas in the instance case, defendants appeared before this court through their counsel on 28/9/2021. On that day, learned counsel for the defendant filed application under Order 9, Rule 7 CPC seeking to set aside the ex parte order and also a memo. Said application was allowed with consent and on consent cost by order dated 18/10/2021. Matter posted for cost and written statement of defendants are also plaintiff objections on memo. On 8/11/2021, the learned counsel for the defendant sought for time stating that it is intending to file an application under section 8 of the Arbitration Conciliation Act. On 29/11/2021, learned counsel for the plaintiffs filed its objections to memo filed by the defendant and both the counsel pressed to take up this matter for settlement on 14/12/2021. On 14/12/2021, plaintiff and his counsel present matter posted on 17/12/21 for settlement, if any. On 17/12/2021, both counsels were present. Copy second set available in the court given to second defendant was also present before the court on that day and second defendant taken time to report settlement by 10/1/2022. On 10/1/2022, though plaintiff counsel was present, there was no representation on behalf of the defendants. Matter called before the Lok Adalat scheduled on 12/3/2022 since both parties absent. Matter posted for written statement by 24/3/2022. Even on 24/3/2022, defendants remained absent with no representation. Accordingly, the written statement of the defendant taken as not filed and matter posted today, 30/3/2022 for plaintiff's evidence. Plaintiff and his counsel present and is filed chief affidavit evidence and PW1. At this stage, the defendant counsel filed the above application under section 8 of the Arbitration Conciliation Act along with service agreements and seeking to refer the matter for arbitration. Since this application has been filed after lapse of 6 months since summons to defendants served on 21/9/2021 and that two defendants having lost their right to file written statement now cannot take shelter under section 8 of the Arbitration and Conciliation Act. Concerning the same and provision of section 8 of the Arbitration Conciliation Act, which is not available to the defendant at this belated stage. Accordingly, application filed under section 8 of the Arbitration Conciliation Act on cost of ₹5,000. Further exam, my application came to be rejected, my lords. My specific contention before my lords is there was a exemption period that limitation for filing whatever the proceedings, my lords, were exempted during the COVID period from 1/4/2021 to 20.
Are you on written statement or are you on section?
On my section 8 application, my lords.
That's all. Then why are we going into that?
Please, my lords. This one, my lords. That's what I did.
For the purpose of section 8.
My lords, my specific contention, my lords. I did not, my right to file the written statement was not forfeited. Is my written submission. The learned trial judge's findings is, my lord, since my right to file the written statement is forfeited, you do not have the right to file section 8.
No, that reason, we will be only testing that reasoning
Please.
for the purpose of section 8.
Please, my lords.
Now, will that reasoning be a relevant consideration to reject section 8?
For my humble submission, my lord, can't be, my lord. My specific contention, my lords, my right to file section 8 is still exists since my application.
One thing. What is relevant for section 8 is if you have
an arbitration agreement.
Filed a reply on merit, then section 8 gets nullified in the sense that
Yes, my lord.
you have expressed your case on merit, hence you are right to seek a reference under 8 would not be available. That's right. But written statement having not been allowed or having not filed got forfeited.
Yes,
As good as there is no representation on merit. Now he says, I am filing section 8. And there is an arbitration clause need to be referred.
Yes, my lords.
Can the court below is right in saying so that since your right to written statement got forfeited, hence you cannot make a application under section 8.
Yes, my lords. My lords, this matter, my lords, this same question that the false, my lords, was considered by a division bench, my lords, of Delhi High Court. My lords, Justice Bakru, my lords, because the Delhi High Court had taken two different views. Now, the Delhi High Court, my lords, via Justice Bakru, has written a detailed opinion, my lords, the moment the right to the forfeiture happens, the moment the close to file written statement is done, you cannot file a section 8 is the stand by the Delhi High Court, my lords. I'll just pass on the judgments. But what is more important, my lords, is the order of 24th of March 2022, which states that, my lords, that the right to file written statement was closed. Now, that is not a subject matter of challenge before this honorable court today, my lords. What has been challenged is the order of 30th of March 2022. I'll just pass on the Delhi High Court judgment, my lords, for a minute. First. What is of significance is, my lords, substance of dispute.
Not later,
Not later than. The date of submission.
Not later than.
Yes, my lords. Now, this was considered, my lords, by the honorable Delhi High Court.
So it can be said that, look here, that you should have filed it at the first instance. And possibly followed by your written statement.
Yes, my lords.
Without prejudice.
And the moment, my lords, the right to file written statement stands closed. Now, at that juncture, my lords, the section 8 would not be maintainable, my lords.
Let's see. So
Yes,
that's the issue which falls for
Yes,
consideration.
yes, my lords.
The relevant consideration is
Plus, para 4.3, my lords, will also say what were the facts before the court. The defendant, my lords, in the matter was served with the matter on 27, my lords, on 29 July 2018 at para 4. Appellant failed to file written statement within a specified period and the matter was adjourned.
Tell us one thing.
Yes, my lords.
Was now when the matter was listed for ex parte evidence of the plaintiff, was did they cross-examine?
No, my lords.
That's
At that juncture, they filed a section 8 application. At that juncture, yes.
So you did not even present him for the chief?
No, that happened. Chief happened. Documents were marked, and he was present for cross-examination. That is also depicted, my lords, on 30th of.
Could you come over with this judgment?
Kindly come, my lords. I have not filed the written statement, my lords. Kindly.
Doesn't make any difference.
May I
The
just
intent
take
is
my
to
lords,
be
my lords, please?
But tell us one thing. Chief was there, you
Yes.
filed your chief, and you got exhibited your documents.
Yes, my lords. And matter was posted for cross-examination.
Matter was posted for cross-examination, and no cross-examination took place.
No, my lords. At that juncture, my lords, is when the section 8 comes to be filed. And after the section 8 rejection, my lords, they file an application for recalling of the order to file written statement. By then, they had come to the High Court and obtained a stay of further proceedings.
They filed an application
They
for
filed,
recall
my lords.
also.
Yes, my lords, subsequently, my
Where do
lords.
you stand then?
My lords, in fact, on the very same day, when I filed my application under section 8, my lords, on the very same day, my lord, without any opportunity to the other side to file objections, my application was rejected on the very same day.
For recall of order.
Not section 8 application.
So did you file any application for recall of the order forfeiting the right to file written statement?
My lords, I filed my section 8. I did not file my application for recalling, my lords.
Oh, that's what he's saying.
My lords, I'll just pass on list of dates as to what.
On that day, we did not file, my lords. Later, we filed an application for recalling that order.
So what does that imply? I'm still ready to file written statement. Forget section 8.
In fact, my lords, my respectful submission, my lords, my 120 days was not expired. Was my respectful submission to file my written submission, written statement. In fact, the only ground the learned trial judge held that I did not have the right to file the written statement. Your application under section 8 can't be allowed. That is the main grounds of the learned trial judge in the order, my lords.
Let's see your prayers in the appeal.
Please, my lords. page 14, my lords. Page 14. Wherefore the appellant prays that this honorable court may be pleased to set aside the order dated 30th March 2022 on IA filed on 30/3/2022, passed in commercial OS number 324 of 2021 at Bangalore, so and so. Allow the IA under section 8 of the Arbitration Conciliation Act filed by the appellants and refer the
It's
dispute.
IA on 33/22.
That is section 8 application, my lords. That is section 8. I am only on section 8 application, my lords.
What is the grounds taken by the learned judge
Kindly, my lords.
on which it rejected it?
Kindly, my lords. If my lords,
The same, it's.
page 23. This application.
This judge.
Yes, my lords. Plus para 18, my lords. My lords, the division bench notes, my lords, there is a divergence in opinion of the Delhi High Court, my lords, at page 6, para 6, my lords. I'll skip over that part, my lords. The finding, my lords, is at para 18 and 19, my lords. 18, my lords, is the first paragraph. At page, internal page 11, my lords. It is clear from the scheme of the act, if I may, my lords. It is clear from the scheme of the act that once the proceedings before the court or judicial authority progresses beyond the initial stage, it would no longer be permissible for a party to then turn around and seek recourse to arbitration. A mere delay in making an application of Section 8 of the Arbitration Conciliation Act may not be fatal to parties' right. But once the proceedings have progressed beyond the stage of completion of pleadings, such an application would not lie. This is because that at that stage, the parties are sufficiently invested in the said proceedings, and it would not be permissible for any party to turn around and apply under 8 of the Act.
And did you seek time to file written statement in the proceedings?
Yes.
In the proceedings, I actually sought for time to file written submission. my
No,
lord.
what is
My
the-
lord, during the interim, my lord, there was a settlement talks were also going between the parties.
See that, to be very frank,
Please, my lord.
doesn't mean that merely because settlement talks, the 120-day will stop running.
My lords,
No.
my respect,
Yes.
my lords, my respectful submission, my lords. As on the date of filing my application under section 88, my right to file written statement was not, I had the full right to file my written statement.
Very well, you should have filed it without prejudice. Could have still filed it. See, otherwise, you know what is happening, what will happen?
Please, my lords.
120 days are approaching.
I understand, my
My section 8 is pending. I will not file written statement. No. To reconcile these facts, what they say is file section 8 first, at the first instance. Without prejudice, file your written statement and contest the section 8. Press your section 8. Even section 8 is rejected, your written statement is on record.
my lords, my submission, my lords, there's an arbitration agreement exists between the parties. That has
Right.
been not disputed
It so
by the other
happens
side.
your section 8 may be accepted,
Please, my lord.
that be. But it was not, and that's the reason, see your conduct.
My lords, yeah, only the means, here the only the ground, my lord, delay in filing my, this one, my lords. Delay in filing my application under section 8.
That delay has been interpreted in this manner. We are in a different regime, you know, we are under a commercial court. Unlike, a normal suit, where written statement, but here it is a case where the right gets forfeited because of the operation of law.
My lords, yeah, my lords, before filing my written statement, my lords, I filed section 8 application is my respectful contention, my lords. Submission. Yeah, I have not filed my written
No,
statement
but
at
this
all.
finding of the learned judge is
Please, my lords.
that you have filed this
At
application
23.
after forfeiting. After forfeiture.
Please, my lord,
Yes,
that's
my
the forfeiting in the sense beyond 120 days.
No, my lord, that's not the way, my lord.
Beyond 120 days is the submission, my lord. Kindly see, my lords, the submission, page 23 is the operative portion, my lords. Since this application has been filed after lapse of 6 months since summons to defendants served on 21/9/2021, and that too defendants having lost their right to file written statement. Now cannot take shelter under section 8 of the Arbitration
So
Conciliation
right
Act.
to, now cannot means that 120 days has expired.
Not been expired is my respectful submission, my lords. This, the finding of the learned trial judge is,
How would you say so?
my lords, during that COVID period, my lord, there's a filing for written statement also, there's an exemption of 2 years from 1/3/2021 to 23/8 to 28/3 to 2022, my lords. So motto, my lords, kindly into that
My lord.
respect, my lords, I have,
See, tell us one thing, this need to be looked into also.
please, my lords.
Here is a person who is actively participating in the proceedings.
Yes.
Ah,
That,
and
time.
appearing, seeking time, doing everything. But when unable to file written statement, then you will say suo moto 3.
In fact, I shown my bona fides regarding settlement also, in the settlement talks were also going
That
on.
will not help your case. I don't think you should.
What is of importance, para 19, my
Lords,
lords, or
in
judgment,
fact-
my lords? Para 19, my lords. of the same judgment, my
My
lord.
lords, in fact, page 22, my lords. In fact, I shown my intention to file section 8 application on 2011-2022 itself, my lords. I shown my 21 itself, saying that I'm intending to file an application section 8. But during the interim, my lord, there was a settlement talks were going on. Since because of that, I did not file the
Not help.
application in time.
That will not help. That will not help. There are n number of judgments.
No, para 19 for a minute, minutes. Of the same judgment, internal page 11.
So just tell us one thing, according to him, the 120 days did not expire when section 8 was filed.
Yes, my lord.
What do you have to say?
My lords, but the right to file written statement was closed.
Was closed?
Yes, my lord. That was closed on 24th of March 2022. And subsequently, on the next day, when the matter was posted for examination.
That closing is before 120 days?
Yes, my lords.
Or before, within that, the initial period of 90 days?
120 days. They had time till 30th of May 2022 to file written statement. The stage to file, the court, my lords, by an order closed the right to file written statement on 24th of March 2022. And they have.
But when was the 120 days expiring?
The 120 my lords was expiring on 30th of May 2022 because of the COVID order.
30th of
Because
May
of the COVID order, my
2022.
lords.
The order is of March 2022, my lords.
And, but tell us one thing, if,
Yes, my lords.
and you did not file any application for recall of that?
I
order?
filed an application recalling later.
Well, they filed an application
We filed
after
on the
the
very
Section 8
same
order
day.
was dismissed. After
After
Section
section
8 order was allowed, my lord.
After section
8 months. That was done on 30th of March 2022. They come
the very
before the
same day
court
filed.
on the subsequent day, that is 8th of.
The list of dates.
No, 3 dates of significance, my lord, 7, 8, 9, 10, my lords. Item number 7, my lords, on 24th of March 2022, written statement was taken as not filed and matter was posted for evidence. 30th of March 2022, appellant defendant filed an application of section 8. Same was rejected via the impugned order on the ground that the right to file written statement was forfeited and application of section was not maintainable after the stage of closure of written statement. On 1/4/2022, defendant presented the present appeal. On 5/4, my lords, the defendant filed an application to recall the order dated.
On 5/4/22 was also 120 days didn't expire.
No, my lords.
May, my lords.
May 30, my lords. May 30th. was 2022.
May 30th of 2022, my lords.
My lords, had they, my lords, I would, in fairness, my lords, had they challenged the order dated 24th of March 2022 before this court, my lord, I would have no standing to my lords today.
Which order?
24th of March 2022.
Forfeiting my right to file.
Had they
this.
challenged that, my lords, I would have no stand, like me to stand, my lords. I would in fairness say, my lords. But today, my lords, having not challenged that, and challenging it 30th of March.
The recall of order of forfeiture is subsequent to your rejection of
Yes.
section 8.
And that's exactly what para 19 of the judgment says, my lords.
That's, I don't think we should now in these facts.
My lords, I will do some more research on this and I will come back, my
No,
lords.
we are clear.
My lords, regarding that, my lords, in fact, undisputedly, there's an arbitration agreement between the parties.
I'm not disputing that, my lords.
The first thing is only file application under 8 once the moment. Yeah, why should I file written statement? Then without prejudice, I'll file
My
written
lords,
statement.
and I have not filed the written statement at all, my lords, as on today.
We'll have it after lunch. Do your research.
My lords,
Pass over. See, the Delhi High Court judgment says otherwise the intent gets defeated, you know.
That's right, my lords.
There is a limited period of 120 days. That gets forfeited, then you will come with section 8. Only to, in a way, overcome what has been forfeited.
That's under a different circumstance.
Very well, look into it. We may be, possibly this may be.
Please, my lord, I'll look into.
Pass over.
Much obliged.
22 urgent, 23, Shabina Ramana, scale number 23.
Yes.
My lord, the appeal has become infectious, my lord.
Has become infectious.
It is filed challenging an order passed in arbitration application. But subsequently, this court has held that the arbitration is not maintainable in the present case and we cannot invoke arbitration at all. So the question of the
Right.
challenge to an arbitration
Want to withdraw this?
if it may be taken up on Tuesday with the signature of a party, my lord, I just need to seek instructions on for filing the memo for withdrawal. For that reason, if it may be taken up on Tuesday, my lord.
We just pass over, take instructions. File
The,
the memo.
the instructions
Pass-
is to file the memo for withdrawal. I'll just file it with the party.
Get the memo.
I'll file it with the party's signature, my lord, if it may be taken up on Tuesday, my lord.
At the request of counsel for the learner counsel for the appellant submits that the appeal has become infructuous and he intends to file a memo for withdrawing the appeal with the signatures of the parties.
Please.
Party. At his request, re-notify.
11th,
Go ahead.
serial number 24.
Lord, I appear for the respondents in respondent in serial number 24. The appellant is unrepresented. I would request that the court takes up the matter for disposal. If I can just give a brief context, my lords. The appeal arises out of an order passed in a Section 9 proceeding that I filed. The Section 9 proceeding was filed because the respondent breached a educator agreement with me and terminated the agreement and left. There was a lock-in period. Therefore, I filed the Section 9 saying deposit to whatever money I am claiming under the agreement. Now, subsequent to filing the appeal, the appellant has rejoined the respondent as an educator.
Yes, now what remains in this?
And nothing remains in this matter because the underlying dispute itself is settled.
So withdraw this.
I am the respondent, my lords. The appellant counsel was also retired. Court notice was sent to him.
Was
I filed a
no
memo.
Notice served on this. Huh?
I filed a memo along with the new agreement that was entered into between the parties. The matter may be disposed
Yes,
of as
pass
having
over.
become infructuous.
And just see notice served. So he's the appellant. This is in Hindi. Service is effected upon the respondent personally as reported by the process. Service is proper and valid. Was notice, sir, was notice issued on the last time? This is the effect of. We'll do a bit. Just, court notice was issued on the last date, no? Just say this, yeah, just say pass over, will pass over. Next,
25 urgent. 26, 27 urgent, 28. 28, Shri Viresh Budihar.
Because I pray for 10 days accommodation, please, my lord.
this, what is the difficulty?
Lords, I'm in Dharwad, my lords. I'll appear before lordships in person and I'll assist the court, please, my lord.
Pardon?
I'm in Dharwad bench, my lords. I will appear before lordships in person and I'll assist the court, please, my lord.
At the request of counsel for the appellant, re-notify.
412.
Obliged.
Serial number 29, Shri Santosh Setia. 29.
Here for the respondent. Who is for the appellant?
Shri Sanjay Setia.
Proxy counsel, my lords, kindly pass it over, my lord. Kindly pass it over, my lords, for that. Obliged.
Pass over.
30, Shri Kumar MN.
Yes, Mr. Kumar.
As undertaken before the Samra Court on 21/7/22, I have deposited the entire amount before Samra Court minutes. I would like to place and record the entire trial court records minutes. Today only have brought the entire material from the officers. My request for a short accommodation.
Ma'am, you appear for the respondent.
I don't.
Khan, you can argue this matter.
I can argue, but papers, whatever is placed before the
It's all right.
arbitrator tribunal as well as before the
A
section 30.
limited point, Mr. Kumar.
Yes, sir.
Whether the delay is attributable to you or not.
That's what I have to place those materials which have been placed, man. That's today only they have brought the all materials. I seek a week's time, I'll place all materials and I will.
See.
That's-
Then we-
Here,
See, what arbitrator has given is what are the, what bills he has raised, he has given that.
that's
And
one.
they were your arbitrators.
So one, secondly, minutes, the delay attributed to the, whether it's contracted to me or a department, which has been explained and the extension is granted under the relevant provisions of the agreement in section 11C, where he is not entitled for the, these are only two factual aspects.
That's right. We'll come back, we'll take it up after lunch. Get ready.
That's my request, at least a 2 days accommodation. I will place materials and then I can refer and make submissions where the arbitrator has committed an error, how the error of jurisdiction has committed and contrary to records that I will point out and then I will.
Who is the counsel, ma'am, for you?
I'm for respondent 1.
You are for respondent number?
1.
You are the contesting party.
Yes, sir.
You are ready?
We are ready. Kindly pass over.
Pass over. We'll pass over.
I request, because if I argue without material before the lordship.
The request of Mr. Kumar, re-notify next week.
Any date will I please.
Just give a date.
I'll place material and then I'll argue.
Just
Close.
get a small issue.
I understand, madam.
1311, sir.
1311, obliged.
Much obliged.
Passed over matters. Serial number 1. Serial number 1, Shri Rudra Bhushan.
Was anyone present on that day?
Sir, respondent is.
But there was no. Where is the last order?
Serial number 1.
29, we have, what happened to 29?
Passed over, sir.
Pass over.
Serial number 1.
Just say that there is none for the appellant. There was even on the second call, There was no presence, there was no appearance for the appellant even on the last date of hearing. The appeal is dismissed as for non-prosecution and in default.
Serial
There
number
was no presence on the last date, no? I still recollect that. Sure, we didn't say anything. None appeared? How do we get that none appeared? Because the order doesn't say so. So none of, just cut that last, just say that none appear for the second call.
13, serial number 13. Satish,
Delay of 19 days, I leave it to this honorable court. Only delay of 19 days, I leave it to this honorable court. And respond number 3, my learned friend may be.
Who appears for the appellant?
Appellant morning also he was absent. As far as respond number 3, my learned friend can appear in that matter. Respond number 3.
What happens is the special land acquisition officer is an officer of the state government. But for the purposes of acquiring the land and passing the award, he acts as a functionary of the NHAI. So I have no difficulty representing him. But in these matters, he's also formal.
Formal part. He is only formal, but there is no.
So I'm in your lordship's hands. Your lordship may either dispense his appearance or I can appear, but usually.
See, it's not, even the challenge was beyond time period. The challenge to the arbitration award.
Yeah, that is for respondent number 3's award, initial award. Initial award challenged by the appellant before the arbitrator. Then arbitrator enhanced certain compensation, that is under challenge before.
No, that award is challenged under 34.
34, that got dismissed. Again,
Dismissed on what ground?
there is no ground as stipulated under section 34(2) of the Arbitration and Conciliation Act. Challenge that he.
Now let's see the merit.
But there is a delay of 19 days.
That we will see, not an issue.
Page number 16 is the finding of the district court, my lord. May I read, my lord?
You are for NHAI?
I am for the NHM. Respond number 2.
How much granted by the authority?
Actually, initial payment was 2,839% for one land, and another set of land is 29,120. That is enhanced from 2,839 to 29,000. That lordship will get at page number 31, my lord. Only thing is I have to get some instruction with regard whether the enhanced portion is paid or not. That I have to get instruction after filing Wakala. First time it has come before lordship. That enhanced compensation also must have been paid by the NHA.
How much was earlier given by the
70,
land acquisition officer?
yeah, 75 lakhs, 75,884. That,
No, per square feet also.
yeah, 2,800. That Lordship will get at page number.
Square meter.
Page number 31, my lord. Page number 30 and 31. It is ordered that compensation for the scheduled land be increased at paid at the rate of rupees 29,120 in respect of converter residential land in survey number 25/2B1 measuring 202.35 square meters and 2,839 in respect of dry land, that is in survey number 25/2B1 measuring 384 square meters of Shiradi village for every cent of land, not square meter, every cent of land. That is pertaining to Mangalore, my lord. So I'll get some more documents. That initial award amount I'm not getting.
What was the last order? Stop. You say there is no appearance for the appellant. In the interest of justice, re-notify. next week.
1311.
Good luck.
Serial number 14.
Yes, ma'am. Can you ask them to switch off the fans? Let's see, the award, ma'am.
Yes. The award starts at page 54, annexure C.
Annexure?
Sorry. Annexure, yeah, B. My apology. It's at page 46, annexure B. Is the award passed by the arbitrator. May I read? May I read? From the beginning, I'll just start. This appeal is taken up for adjudication under section 3G5 of National Highways Act 1956. The first respondent has acquired the lands belonging to the appellant for widening the National Highway number 4. This appeal is filed against the award passed by first respondent. The appellant has stated that the quantum of compensation awarded is too inadequate and has urged this authority to enhance the compensation. The Government of India in its order number so-and-so dated so-and-so has designated the Deputy Commissioner Devangiri as arbitrator to resolve the disputes relating to the widening of Withdrawal number 4. Accordingly, this appeal has been taken up for adjudication. The National Highway Authority of India, this page 47. The National Highway Authority of India taken up the widening of heir Chitradurga National Highway number 4, 4 lines road in survey. You know, this paragraph is on mainly on then I will just go middle of that paragraph. Further, the final notification wide number so-and-so dated 9/7/2013 was issued by acquiring so-and-so land belonging to petitioner in survey number so-and-so was acquired. Pursuant to the final notification, an award was passed by the respondent as per the orders in number so-and-so dated 21/11/2030 by fixing an award of rupees 8,25,000 as land compensation without considering the factors prevailing on the spot. The petitioners and the respondents were given sufficient opportunities to prove their pleading from date 16/2/2015 to 29/4/2016. Both the parties have put forth the different contentions and documents to prove their case and submitted their detailed oral and written arguments to uphold their contentions as taken by them in their pleadings, and the same were heard in detail. All the documents filed by both the parties were perused in detail. The petitioner being aggrieved by the said compensation awarded by the respondent as stated above, the petitioner filed the petitioner before this authority challenging the validity and correctness of the award passed by the respondent. On the several grounds as stated above and prayed for an order for enhancing the additional payment of compensation. The petitioner further contended that the respondent, while passing award, not taken into consideration prevailing circumstances of the spot and mechanically awarded the compensation without taking into consideration of the potential value and instead considered the acquired land as agriculture land. The respondent never considered the potentiality of the land acquired by the land acquisition officer while fixing the compensation. The land acquired by the respondent which belonged to the petitioner comes within the purview of Davangere City and within the jurisdiction of Ward number 40 of Davangere City Municipal Corporation. Further, the land acquired is abutting to Karnataka Housing Board Colony, which is highly equipped residential area in Davangere City. Further, the lands surrounded, the land acquired are already turned out to be a residential layout.
What do you say on this?
Sorry?
What do you say on this?
Yes, my lord, in my resource submission, I mean, honestly, I'm not aware how far or how close this colon is there. But this colon is, as mentioned here itself, it is residential layout. So it is non-agriculture and layout is formed. While
How much the land acquisition officer awarded?
it awarded, land acquisition officer awarded 15 lakhs per acre.
Will that 56 also suffice? May not be 400, but will 56 is also a reasonable compensation?
Right now, my lord, I am here before this honorable court to challenge district court order where they confirmed arbitral award. I'm not justifying SLU's award here. I'm questioning arbitral award. I'm not saying that 34 or 15 lakhs was right or wrong. I'm not on that at all. But I'm here before this honorable court questioning arbitral award, awarding 400 rupees per square feet, relying upon saying that this rate, this is market value for this land in Karnataka Housing Board layout. In my sole submission, when guidelines are prescribed, it's always like, now what is the value of, it's always different value for agricultural land and non-agricultural land. When agricultural land, like when you go for conversion, you have to pay conversion fee, and again, you have to leave certain land for road and other. And when layout, it's a more the reason. There is a land reserved for road, land reserved for park, various things whenever layout is formed. So they have to leave certain lands. Here he is getting compensation for entire extent. And because it is agricultural land, and here I'm just going further here. They say much less. Much less. The petitioner was also intending to convert their land.
This is not a PHP. This is only a agricultural land. Could not have been. Yes.
I mean, I will just go read one more line. Much less. The petitioner was also intending to convert their land.
That's right, that's right.
Now I request your lordship to look at the impugned judgment, which is at annexure A, starts at page 22. I'm just reading.
This is the only issue. This observation, near KHB intending to convert into a layout.
No, not layout. He was intending to convert his land. That clearly shows it was agricultural land. That clearly shows it was agricultural land. And how he got to know that he was intending. Intention has no meaning. Ultimately, whether converted or not, he was intending after acquisition.
Also, you have no role
Without,
and like an amicus.
my lords.
Yes.
May I say this, my lord? There appear to be two factors. The first is that the land in question now falls within the Davangere, the city limits. What happens, my lords, is there are two factors. One is what is the nature of the land for the purposes of revenue? Is it agricultural or non-agricultural? The second is, which is the municipal authority? Is it the village panchayat or is it now within town municipal corporation limits? And what is the planning, zoning, etc. From a development point of view? That appears to be one finding. So it appears to have now come within a town municipal corporation limits. Then my learned friend is absolutely right that intending to convert, etc. is a secondary issue. It may, I mean, it's less relevant or even irrelevant. But abutting a residential layout would therefore mean that there is potential other people may want to reside, etc., etc. The question for your lordships, my lords, if I may submit.
You're right, but But once, now you have to, it's not a part of layout.
It is not a part of layout.
It has not been converted.
It has not been converted.
It cannot be 400.
That, my lord, I don't want to guess a number.
No, but he goes that 380 is the KHB. Market value is now 400. See, KHB can't be compared to unequals.
My lords.
But that's what we have put it, surely not 56. There must be something in between. What is that in between need to be looked into?
The difficulty, my lord, is in 37, whether I only submit that your lordships may have to.
Suppose 400 is perverse.
Your lordships may have to set it aside, my lords.
I know, you're right, we know that.
If your lordships come to the conclusion that 400 is perverse.
No, we are just only putting to, you're right, it need to be set aside, we can't modify. We can't say 400 should be 150.
Because what happens, my lord, is although I understand your lordships when dealing with a land loser's case have the equitable and akin to a writ jurisdiction, an equitable mindset. But my lords, because it comes via 34.
I know, but see, so surely the justification according to her is not, the comparison is not proper. The basis is not correct.
The basis, my lords, because
surely a layout will be different from, will fetch higher than an agriculture land.
If I may request your lordships to.
Yes.
The reasoning, my lords. He relies on the master plan. As per the master plan produced by the petitioner, acquired land comes within the purview of the master plan prepared by Davangere Harihara local planning area. It goes to show that the acquired land is situated well within the city municipal corporation limit of Davangere. That is the first finding. The second is undisputedly adjacent to the Karnataka Housing Board colony. So if I may, my lords, ignore the second for the purposes of whether it's 400, 300, 250, etc. Ignore the, what becomes relevant is it is now within city municipal corporation.
But tell us one thing, what prevented him to look into the rates which were prevalent for agriculture land?
I can only
adjusted to it.
I can only guess
But
absence
we are
of
going
a
on
judicial
comparison.
mindset.
He should have only said, look here, you are right, KHB, but this is agriculture land within the municipal limits of the city. This agriculture, the attached subsequent agriculture land fetches this much. I'll take it as a yardstick.
Yes, ma'am.
No issue.
There would have had to be some
reasonable nexus.
Reasonable.
But to say that comparison is with the layout.
I understand.
He may be right in saying so within the limits, municipal limits, but he will still not draw a conclusion of 400 unless he says even within the limits, the adjacent land to this, which is an agriculture land as different from KHB land, would fetch this much.
What happens, my lord, is after the table, he says, hence basically on spot the properties of fetching market value of rupees 1,000 to 1,500 per square feet. The respondent passed a blanket award unscientifically and contrary to natural justice at the rate of 8,25,000. In short, it should have been 1,36,19,000 so and so at the rate of 568 per square feet.
That is the argument of the other side. Was it an argument?
It was an argument, my lord. So the rate that is submitted is 568. As per the other side, the first contesting respondent over here. And from 568, he somehow reaches 400. So that is the amount of
568, everything he's computing, solatium, all those.
Yes, yes, yes.
So that's the reason we wanted to know how much we are in 34.
Yes.
When two views are possible, one view is taken, no interference. That's also. But which is the second view? second view is within Devangare, the city limits. The land fetches, let's assume 388 or just nearing 400. So I pick up 400, a reasonable nexus.
Yes.
He should have more gone on the city limits and then concluded what is the land price.
Yes.
And then awarded.
Perhaps recorded some contemporaneous transactions.
But if you see the National Highways Act, this 3G5, 3G7, those parameters which have been given, the relevant considerations is, see, ultimately you have, if the land is taken away from you, there would be sort of a prejudice that is going. Maybe you are relying upon those agricultural land for your sustenance.
My lords.
That's a hardship which will cause.
My lords.
Okay. And there are few other considerations which must weigh with the authority to determine the compensation.
My lords.
Here there was only one relevant consideration. What is the adjacent land was fetching?
In other words, A, what is the market value?
He has only gone by that.
Yes.
Now, market value can only be seen by a document duly registered and which is adjacent, but not which are uncomparable.
Comparison needs to be apples to apples. Comparison needs to be of like objects.
But see the variation from the original award which has been passed by the Land Acquisition Office.
Lord, that
and enhanced by the learned arbitrator. See the disparity.
My lords, that what happens is in a given case, I'm not on this. In a given case, the impact of development is that. So, for example, you know, our international airport today in Devanahalli, we used to farm in Devanahalli, and to go there was a day trip. Today, there are taxi operators that are making that same trip 6 times a day. So the impact, so when the airport came up and the highway was constructed, in fact, orders of this honorable court said that highway should be without signals, etc., etc. It skyrocketed.
Right. Today, everything may be, today possibly maybe she would also agree that this land would be maybe what 400, much beyond that.
So the interregnum, the factual inquiry, my lord, should have been, as your lordships have rightly pointed out, that what is the he has treated it as agricultural land without taking into consideration its town corporation limit. Even the SLAO says that it is adjacent to the NHB. Let us ignore that for the time being. What is the impact of the inclusion in the town municipal corporation limits or the city municipal corporation limits? That should have been the driving factor, and perhaps some comparable transactions, some comparable private transactions.
He should have only said very within city limit, this is the comparable transaction.
Yes, my lords.
I will go by that.
My lords.
Not on a KHB.
My lords.
Because the very.
Because
but the only thing is, if it is on that, you know, we are seeking on that day of the notification. This is happened in 2010, na?
Yes.
2012 was the notification.
2012.
How far is Devangre from here?
Davangere, lots about subject to correction, maybe about 3 hours. More.
Surely not near Bangalore.
No, definitely.
But 4 hours.
4 hours.
Cross Chitradurga and then.
Ma'am, show us any judgment, ma'am. We wanted to know, you know, what is how the provision has been interpreted and mind it. Although there is one order which we have also passed, where the learned arbitrator has taken into consideration based on 3G7, which have 5-6 considerations. He has taken into consideration four relevant parameters to hold. There was not much of a difference. There were 3 cents. The effective increase was around 80,000. We did not interfere in because it's 80,000 only. We did not interfere. But in a given case, whether those principles we are laid down, it will be across the board, it will be applicable. Whether it is a small land or a bigger land, everything. on, suppose on square feet basis or percent basis or per acre basis. So we wanted to be clear that on an interpretation of these provisions, now in this case, out of 5, 6, he only takes into consideration one relevant point.
Because that was.
That's marketing.
Even claim was not for one other aspect, Milord. Landowner's claim was also not another aspect. So it was only for market value.
Based on KHB.
Approached arbitrator for market value, 3G7A, and market value has been.
And do they say that does the arbitrator relies upon KHB, refers to KHB or land acquisition officer?
No, it's arbitrator who refers to.
And what does the land acquisition?
Land acquisition officer said that guidance value. And so when my learned friend is submitting that it's within the municipal corporation limit and all this. So as this guidelines value also, when it is fixed, it takes into consideration all the aspects. So though it was within that limited municipal limit, still guidelines value, there is a committee which decides on guidance value and then government notifies it. So in that, guidance value is fixed as 15 lakhs per acre, taking into consideration all the aspect. For agricultural land, it was 15 lakhs per acre. So SLO requested Subsar office to give sales statistic and guidance value. Based on that, he has decided. And even when sale deed was produced, so that also it is taken, and sale deed, one sale deed was produced by one of the landowners before SLO.
Shows that.
And SLO, after, it has lesser value. So then he said, I'm giving higher, which is guidelines value.
I think about 6 lakhs is the. 6 lakhs.
Your memory is good.
And that was produced by the petitioner himself.
One of the landowner.
The landowner.
Let's see the award.
Annexure C, SLO's award starts at page 54, and your lordship would find this on page 58. As seen, your lordship, what, page 80, page 58. As seen from the copy of sale deed bearing SR number so-and-so dated 5th October 2012, produced by Shri Ramana Gowda, Hiregowda Patil, an extent of 25.5 kuntas in survey number 101 by 22A4, purchased by him for rupees 6 lakhs only, which works out to rupees 9,41,176 per acre. But the said transaction has taken place after publication of stay notification.
This is in which survey number?
(101/2 API). 101/2, 101/2
Yes,
AP2,
1 by
2 AP3.
So it is adjacent. So this is lesser, 9,41,176 per acre, that sale deed, which is even subsequent, just then. So that's why they have not taken into consideration and given 15 lakhs per acre, which was guidelines value.
Just see page 59.
59, yes.
In her claim application, she has stated lands under acquisition within the limits of Devangre in developed residential commercial.
That is
Further, she has stated that the present market
That is
price.
non-agricultural land.
No, 1 crore per acre, and the guidance is the 20 lakh per acre. Nearer this land, Kannada Housing Board acquired 300 acres, layout, distributed it, she continued today. In total, the aforesaid claim comes to this. Since no documentary evidence is adduced in support of her claim that such high compensation per claim is not considered, more so 12% additional value. So this municipal limits was also considered. The housing, Karnataka Housing Board layout also considered. But no documentary evidence. Has she produced any documentary evidence? But even before the arbitrator, now what is the basis for the arbitrator to also to draw a conclusion on the basis of housing board layout? See, if you have that page 59.
Yes.
under discretionary court of order, she continued to state that the said land acquisition surrounded by developed area, Karnataka Housing Labor, Bapuji, this is Angre, recalls this, so she has also requested to consider. In total, the aforesaid is this. Since no documentary evidence is adduced in support of her claim of such higher compensation, her claim. What is KHB basis for her to grant? Has she placed before KHB this thing?
And Lord, here it shows that even spot inspection was carried out.
They say so.
Yes.
You say, brother.
Before the arbitrator, there appears to be sale deeds and a report produced before. It says the district registrar is of the opinion that the property situated in an area around 101 having high potential, and in this regard, reports are also produced. So,
Where are you reading?
my lord, it's the award, my lord.
No, where does the award say?
48.
Where does the award say?
That's about page 48.
48 is not the which award?
The arbitrator's award.
Arbitrator award. Okay, okay. 48.
That's
In my response submission, there is a high potentiality. I'm ready to assume that. But whether that high potentiality can be equivalent to layout value, that is my point. Everything we are ready to assume. Yes, it is high potentiality, this report is there, everything.
about the middle of the page.
Because unless conversion is done, that land cannot be considered as converted land.
Sale deeds, sale deeds were of KHB.
Perhaps.
Past inspecting the swap, property abutting Karnataka, where the property allotted to Karnataka, the market adjacent to the layout. Sale deeds produced by the petitioner. Moreover, the district registrar is of the opinion of property situated in area 101 high potential value, and in the regard reports.
And there is a report that is mentioned there that he seems to have considered.
Arbitrator's record called for before the trial court, sir? Before the trial court, arbitrator's record was called for.
I request your lordship to look at the impugned judgment, which is annexure A. It starts at page 22. And I request your lordship to look at page 40. This is what we have challenged before. Lord, annexure A starts at page 22. That is a
page 40.
district and sessions judge, 34 judgment passed in 34 petition. It starts at page 22. I request your lordship to look at page 40. Page 40, paragraph 28. I'm just reading. If only the provision of act are not properly followed by defendant number one, then we can see that the award is in conflict with the public policy of India. However, the approved layout plan produced before the defendant number one by defendant number two shows that it was prepared as per the government letter number so and so, dated 26/7/2008. Full stop. According to this approved layout plan, the learned arbitrator has held that the alleged acquired property comes within the approved layout plan of Davangere Harihar city. Based on it, he fixed the market value of the property, which is completely false premise on which he decides this. And he confirms arbitral award based on just one paragraph.
The court should have said master plan because the arbitrator says
What
master.
should have, no, I mean, I'm not
Yeah.
here, keep what he should have done, what arbitrator should have done,
It is a-
what he has done,
It's a-
what he is saying.
It's a gap. It's a problem.
No, he's saying that it is within the layout. Approved layout plan produced before so and so by so and so, that it was prepared as so and so. According to this approved layout plan, our learned arbitrator has held that the alleged acquired property comes within the approved layout plan. So this is a false premise on which he is deciding that arbitral award is correct.
There was no representation for their side.
On last date of hearing also, they were
Yeah.
not there. Oh, Today morning also when called out, I mean, no one, today morning also when matter was called out, no one represented respondent number one. I mean, it is served and like, I mean, Vakalt also has been filed by, power has been filed by.
Just notify the name, man. Will that name be notified?
In my respectful submission, it is fit case for setting aside the, washing the district court's
Okay.
judgment.
Jesse will take it up once after lunch. Then it's yellow, pass. Next,
Serial number 20. The BM Siddhappa. Serial number 20.
Application my lord was filed under section 8, my lord, it came to be allowed. That was, my lord, matter was taken up in the morning session, my lord. She appeared online.
who appeared?
Colleague of Mrs. Siddhappa appeared online. Section 8 application was filed by the defendant respondent. And not considering that there is a specific arbitration clause in the agreement, it's a loan agreement, where there's a default committed by the appellant. And as against that, he filed a suit restraining the defendant from taking away the vehicles which were under the mortgage.
But on what premise the section 8 was being contested? Despite an arbitration clause?
They say that it is objection they have filed. They rely upon one judgment of this honorable court. That is discussions at page number 17 of the impugned order. May I not read 15. For the learned counsel for the plaintiff has relied upon the aforesaid judgments, taking into support of the observation made in the aforesaid judgments. Learned counsel for the plaintiff argues that the present suit is maintainable under section 8 of arbitration does not attract the facts and circumstances of the present case. In light of the arguments addressed by the learned counsel for the plaintiff, I've gone through the aforesaid judgments. That's first judgment, heir 2016 SC 1441, which refers to the defining the court, where it is stated that the court can exercise the power specified in the second schedule of the act. However, arbitrator is not a court. Arbitrator is the outcome of agreement. He decides the dispute as per the agreement entered into between the parties. Arbitration is an alternative forum for resolution of disputes, but an arbitrator ipso facto does not enjoy or possess all the powers conferred on the courts of law. However, here is the case. It is the contention of the defendant that there is an arbitration clause as per Section 8 of the Arbitration Act, and the present suit in the forum is not maintainable. On perusal of the observation made in the aforesaid judgment as reproduced herein, I am of the opinion that the said observation, that is defining the court, may not help to the plaintiff in deciding the present suit. That is not the contention that has been taken. And not it is settled, not law.
Who is the
relied
counsel
upon
PM
the Sundaram Finance judgment. Similar circumstances, not a judgment of the apex.
She is the counsel then?
No, no, no. Sir.
On what proposition?
Lord, regarding
finance.
Lord, it's a finance related issue, but and again, Section 8, the scope of Section 8, Lord, is discussed. May I, Lord, produce?
But their objection is not any substantial objection.
Please.
To Section 8, if you just see this.
The existence of the loan agreement is not disputed. The arbitration clause also is not disputed.
See, come to page 15.
Please.
That's what noted. Plaintiff contended have not made all agreements related to defendant are created, including the clause of arbitration. Further, plaintiff contended suit is only for permanent. Now she said, again, when the first scripture has not filed any return statement. There was some appearance for the.
Please, Lord. On behalf of Mr. Siddhappa, Lord, there is a counsel who represented in the morning session. But her video, Lord, went off after some time, after a few minutes.
We'll just see Passover. Let's see. Please. We'll take it up after lunch.
But may I be permitted to, my Lord, appear online, Lord, because I have a matter in Dhawad. I've just, Lord, passed on, Lord, 2 judgments of the Apex Court, Lord, judgment of the Apex Court. In the afternoon session, Lord,
21.
Why was it passed over?
21.
At 2:30, regarding this 21.
Okay.
Please.
24. Abhishek Kumar appellant, Kashyap Naik.
Just say that despite service has been effected on the appellant, despite a court notice having been effected on the appellant, this is for June. That's the point. Did we just ask registry, did they send it? Notice, court notice? You should know now, there is no. You just confirm from that, then we will see.
29. 29, to Sanjay Sethia.
Yes.
For the appellate, please, sir.
Let's, may I request a short accommodation, my lords?
All right, let's hear him. We have to do some work. Yes, come.
The suit, my lord, of the respondent, which came to be decreed, my lords, has been challenged by me. The decree has been challenged by me before this in this appeal. Judgment is of dated 7th of December 2021, whereby the commercial court has decreed the suit of the plaintiff, directing the defendant to pay 81,85,513 with current and future interest at the rate of 9% per annum on the principal sum of rupees, my lords, of 45,37,781, along with the notice charges of 20,000 rupees. My lords, the suit of the plaintiff arises out of the claim on the ground that there were certain deposits made by them in the first defendant company, the defendant company, and that investments which were made by way of deposits or the loan which was advanced by way of deposits would have to be refunded. That's the crux of the suit, please, my lords. And that has been claimed with an amount of interest as well from the date of the payment till the date of the repayment by the defendant. My lords, between the plaintiff and the defendant company, there arose a dispute in the year 2013. At which point in time, my lords, what happened was, I will take one of the documents that I relied upon before the trial court, which is the crux of the entire dispute, please, my lords. Exhibit D4, document 31, page 159 in the compilation which I filed. That is the, lords, as the MOU. The Memorandum of Understanding executed on the 16th January 2013.
What does MOU say?
My lords,
What does MOU say?
when the dispute arose, my lords, between the defendant and the plaintiff,
Which page you said?
page number 159, document number 31, exhibited as exhibit D4 before the trial court, which is the defense of the appellant before the trial court also, basis of this document, please, my lords.
Yes.
Page 160, please, my lords. From where the document starts. Page 159 is the document, page 160. Dr. Ritish Kumar, Bhargav Ram, Kupuswamy. Now the present suit is by Bhargav Ram against the company which is represented by Dr. Ritish Kumar. My lords, page 162 of the document, para 8.
Yes.
During the pendency of the aforesaid proceedings, the second party have inducted two additional directors, Vasu Annamalai, Syed Akbar Hussainini, to the company without any equity in the company. That apart, the second party has also opened 2 new accounts in IDBI Bank in favor of Chiguru Cancer Care Private Limited, bearing account number so-and-so, and another account number Cancer Care, Karnataka Cancer Care Hospital, bearing account number so-and-so, and operating the same. The second party have also, during the pendency of the aforesaid proceedings, alienated non-residential property of the company bearing number 99, situated at Krishnananda Nagar, Jarka Bande Kaval, Nandini Layout, Bangalore, 2 and in favor of 1 Vasu Annamalai and Govind Raju under a registered sale deed dated 27/9/2012. The said Vasu Annamalai is additional director of the company and A. Govind Raju is his brother. In order to put an end to ongoing differences and litigation amongst the first party and second party and the other directors, the parties have mutually discussed and arrived at an amicable settlement, the terms of which are as under. Let's para 1, those other parties have resigned from the directorship. Para number 2, the new director is inducted. Para number 3, please, my lords. The second party agrees that upon entering into this MOU, they would relinquish all their rights, title, and interest in the company of whatsoever nature to and in favor of the first party and or any other person nominated by the first party. 4, 5, I'll skip, my lords. 6 is the relevant one. In pursuance to the aforesaid settlement, the first party has this day purchased some 56,667 shares of Dr. Bagaram at the rate of 3 per share by paying 1,70,000 by cash to Dr. Bagaram. Bagaram is the plaintiff, my lords, and he acknowledges receipt of the same. Likewise, the first party has also purchased the share of Kupuswamy. Then, my lords, para 8. The company has availed loan for a purchase of medicinal equipment with linear laparoscopic equipment from Reliance Capital, and the outstanding amount as on date is 3,46,32,718, which includes the principal and interest. The first party agrees to take over the loan from the Reliance Capital Limited and settle the same within 6 months from the date of execution of this MOU by getting discharged the collateral securities submitted by the second party. In case the first party requires further time, the same shall be extended extended by the parties for a period of 3 months. Para 9, apart from the aforesaid sums paid towards the purchase of share, Dr. Bhargav Ram, that is the plaintiff, has been paid with all his investments previously, and he acknowledges receipt of the same. Dr. Bhargav Ram further confirms that he has no claims against the first party or the company in whatsoever manner. Towards refund of the investments paid by Kupuswamy, following sums have been paid. Next page, please, my lords, at para 12, clause 12, 165 page. Apart from the aforesaid dues with the Reliance Capital, the second party and the consenting witnesses agree and confirm that there are no other outstanding payable by the company except the amounts mentioned thereof. Let's, under these circumstances, all the differences and disputes between the parties came to an end by virtue of this MOU on the 16th of January 2013. My lords, the very basis is that, my lords, the present suit is, there is a deposit which has been treated as an unsecured loan in the year 2012. Therefore, that amount would have to be refunded as and when the same has been claimed. The first contention is that, my lords, the whole dispute between the parties was that there was a property of the company, and that property came to be sold by opening 2 other bank accounts, during which time the present director was forced to sign all the papers. Even he was made to sit outside the company, and that is when the suits came to be filed and injunction were obtained. During that period where the documents were signed and the suit was filed and the compromise could take place, the property came to be sold, and the entire money were paid under the new bank accounts which were opened by these parties. Okay. Therefore, to put to an end to all of this, wherein all the monies were taken away by them, we took over the company, please, my lords. Now, after a period of 11 years from the date of settlement, a present suit came to be filed, claiming that the money which was paid during that point in time is now repayable. The basis of this claim is that, my lords, Article 22 of the Limitation Act. If I take your lordships through the Article 22 of the Limitation Act, for money deposited under an agreement, that it shall be payable on demand. It includes money of a customer in the hands of his banker, so payable. In the schedule, Article 22, please, my lords, in the first schedule. That is the basis on which they frame the suit to say, when the demand is made, from that 3 years, the limitation starts. Now, my lords, first, the prima facie point that comes to the consideration is whether the money is a deposit qualifying under the Limitation Act. I will now, my lords,
yes.
I may request this honorable court to exhibit P33 at page number 110 may be looked into, please, my lords. which is the basis of the entire claim.
Okay.
Exhibit P33, page 110.
Balance sheet. Yes.
Page 110 is the statement of profit and losses. 115 is the relevant page, please, my lord. 115 is the relevant page. Unsecured loans. Dr. Bhargav Ram, 45,37,781. That is the suit claim. Please, my lord. Now, the contention is that the money which is shown as unsecured loans are nothing else than the deposit as per the Article 22 of the Limitation Act. Now, my lords, the question arises the two folds. Article 19 would say that for money payable for money lent, when the loan is made is the date on which the limitation would start from. If it is a money lent, according to them, as per Exhibit P33, please, my lords, then, my lords, the limitation should be arising from the date the money was lent. Two, my lords, even if I take Article 23, my lords, for money payable to the plaintiff for the money paid for the defendant as an investment, supposing, please, my lords, even then the money, it should be from the date on which the money is paid. Now, the only Article 22, it says that since it is called as a deposit, my lords, Article 22 categorically specifies that the deposit should be by way of an agreement. There is no agreement at all between the parties. It is an unsecured loan. Now, this money was paid. I will now take your lordship through the plaint averments. How and for what?
We'll come back after lunch.
Please, my lords.
One indulgence notes, your lordship said on the other day, modified an order of the learned single judge in the Court of Appeal relating to release of certain goods. I'm told a series of orders have been passed. Not may I, it's out of turn, but may I request for it to be had on Monday? If I may pass over the memo.
No, what is that?
The under section 130.
129 and 107.
Yes, ma'am. Title passes to me and I'm being asked to release a series of goods against 25% deposit.
But we left that question open, no?
Please, my lords, that remains my contention. But your lordships were kind enough to impose certain conditions, bank guarantee, personal bond, etc.
No, that was release of bank guarantee and the vehicle.
Yes, yes. So therefore, my lords, a series of orders.
What we have said was, since the already released, 25% deposited, already released, question of law left open to be decided in a more appropriate case.
My lord, this is against an interim order. Your lordships are referring to a final judgment that was
No,
passed.
we are not. We still recollect it. Against 129 appeal file, appeal dismissed, learner single judge is seized of that issue.
My lords, I had mentioned a matter where against that was a case where, my lords, the appeal pre-deposit versus this was another interim order where your lordships had disposed of.
Oh, yes.
So following that, citing that interim order which your lordships were pleased to modify, a series of orders are being passed by the learned single judge. I am only seeking parity that certain further conditions be imposed in terms of furnishing bank.
Based on our judgment being modified?
No, my lords.
No.
In the interregnum, before I came to your lordships.
Based on the earlier one, that 4 lakhs.
I'm only requesting if the matters can be had on Monday. There are 3 matters.
Is it on the board? There is any date there?
No, my lord, it's a fresh matter.
Oh, it's a fresh matter.
I had the option of moving it tomorrow, but it'll be more convenient to the registry if I'm.
You filed it?
It's been filed. It's filed number.
Moving now.
I'm only, my lords, for Monday, but I'm only presenting the memos now with apologies. Unusual to take it at 1:30.
But is there any caveat in there?
My lords, no caveats, my lord. There are contempts have been filed. I'll notify the council that are appearing in the.
You notify the council, mention it tomorrow morning.
Very well.
Just a short accommodation minutes.
See. We just see, let's see in what manner we proceed under them. Let's see, be here.
Much obliged.
Just call him. This council. You wanted an accommodation, na, post lunch. Where is the counsel for the appellant? We'll call him. Because we have other 2-3 matters, I think that would also, we can get engaged. We will.
Milord, is it serial number 14, Milord?
No, ma'am, not 14. We'll
Sorry,
come back.
my apology, my apology.
Just give the date to him. No? Come.
29.
Ma'am, we'll have it, we will adjourn this matter. No, not yours. We'll adjourn this matter, just give a date to them. At the request of counsel for the respondent, we'll have it some other day.
Can it be on 20th, my lords?
Not your matter.
No, this one only,
Same matter.
29,
Same.
29
Please
only,
represent.
ma'am, 29.
We go by the person who appears before us.
The 20th, please, my lord.
Just give it. Monday, is it Monday?
Sir, Wednesday. sir.
Wednesday. See the diary also, see our board. Huh? Ah,
20th.
much obliged. We will give it 20. Grateful. Now you come.
I
Come. Your matter, you don't want to argue.
No, my lords.
You have argued.
He has 3 more matters in the same court, my lords. We don't know which matter is appearing in. He has 3 other matters.
for 21 only. 21.
Yes, sir, my lords.
Lords,
Yes.
in fact,
Which is the best judgment you have?
lords, in fact, the Honorable Delhi High Court judgment will be helping me only, my lords. in
Very
that
good.
matter. Please, my lords.
So which para helps you?
From kindly, my lords, paragraph 3, my lords. If my lords permit me to read, my lords. The principal question that is required to be addressed.
See, where is the judgment? Yes.
My lord, it was a judgment in respect of a general circumstance, not during the COVID period, my lord. This judgment is not pertaining to the COVID period. My case is entirely between the COVID period, my lord. In fact, my lord, kindly peruse paragraph 3 of the judgment, my lords. The principal question that is required to be addressed is whether a party forfeits its right to file an application under Section 8 of the Arbitration Conciliation Act on expiry of the time to file a written statement of its defense. Now onwards, my lord, kindly come to paragraph 17 onwards, my lord. Only question that arises for my lord's consideration in the Delhi High Court, Honorable Delhi High Court, whether my right to file a written statement has expired or not. Yeah, kindly come to paragraph 17, my lords.
That's all right, but those were in those facts.
Yeah, my lords, in this
Expired.
matter, my lord, the admitted situation, my lords, up to 28 to 2022 was the COVID exemption period, my lords. Limitation expired period.
We will not take it.
But as on today, my right to file a written statement was available up to May 2022, my lords.
But tell us one thing. The person who appears every day may have 10 litigations
Lords, yeah.
contesting. And then take the plea of, COVID. Can one take the plea of COVID? Although for all purposes that litigant was in the court only.
My respectful submission, my lord, in the peculiar circumstances, my lords, the contact of the parties can't be a relevant factor here, my lords. Contact of the party can't be a
We are
relevant
only
factor.
saying, we are only saying. Except the fact what we are finding in difference is in that 120 days had expired. In this 120 days not expired.
Not expired.
But the right to file written statement forfeited.
Please, my lords. My lords,
That's-
yeah, that was my right to file the written statement is not being forfeited in view of the COVID period, COVID exemption.
That possibly we are unable to accept.
That's
Tell us one thing. You were before the court. See, the intent is this. Were you, because of the prevailing circumstances, prevented from even appearing in the court? Prevented because of that not filing the written statement, or even prevented from filing an application under 8? It is not such a case. All the 3 eventualities are not there. Getting the point?
I got it.
You were appearing.
Please, my lords.
You were seeking time. You did not file written statement. Neither on the first instance you filed Section 8.
I do agree, my lords. Regarding the contact, there is some lapses on my part, my lords.
See, strictly to be very
Regarding the contact, my lords, I fairly agree, my lords. There's lapses on my part.
and mind it, there are judgments in the context of COVID. A person who was available all throughout, who has been not only pursuing this litigation, he has 5 other litigation pursuing those. In those, he completes the pleading except in this and seek the plea of COVID disallowed. It is something, because of COVID, you were prevented.
Fact. Regarding the contact, my lords, I have a weak case. Weak case, my lord. But here, my lords, at least judgment of the Honorable Supreme Court regarding the protocol, my lord, 2022, which says that the time That limitation period applies to the filing of written statement also is the judgment, what I am relying upon.
That's right. There is no dispute. But the fact remained, your right to file written statement was forfeited. But you say for COVID reasons, it could not have been forfeited.
Please, my lords. Now, if my lords now come to section 8, my lords, at any stage of the proceedings, before filing my first statement of defense, is that one. As on today, admittedly, I have not filed my application of my written statement.
That's what I have put it to him.
As on today, I have not.
What I have put it to him, effectively, there is no written statement on merit. There is no stand of yours on merit.
Please, my lords.
Till you file section 8.
Please, my lords.
Effectively, that requirement is fulfilled.
Please, my lords.
That's what we have put it to him. So why not? It should be allowed. But his submission is based on Delhi. He said nothing. Having right closed of filing a written statement, now filing a section 8 is nothing but to only to circumvent what has happened by the court forfeiting your right to.
Well, it's not only that, my lord. During that interim, my lord, there's a talks regarding the settlement also going on. If my lords come to paragraph 26, my lords, I don't want to trouble my lords with the other things. 26 of the Delhi High Court judgment, my lords. Incidentally, if a party fails to file an application under section 8(1) of the Arbitration Conciliation Act for referring the parties to arbitration within the time available or granted for filing the first statement on the substance of the dispute, which would include a written statement in the context of a suit, the party would forfeit its right to apply under section 8(1) of the Arbitration Conciliation Act. My respectful submission, my lords, as on today, my right to file the written statement is still available. As on that day, as on the date of the order. In view of the judgment, my lord, this judgment will be applicable, will help me only in this context, my lord. And it's in
Then why didn't you challenge that order of forfeiture?
My lord,
Closing your right.
My lord, I filed an application for recalling, but that did not. In the meantime, I filed this.
What happened to that application?
At the pending, because the order has been stayed, the entire proceedings has been stayed by this honorable court on the first occasion. If my lord kindly.
Now tell us one thing, when did you file that application for recall?
On the very same day, my lords. On the very same day.
No, my lord, that's not right. They filed it on the 5th of April, my lords, after 5 days after the impugned order was passed.
And 18th, I filed the appeal before this honorable court. On 18th of April 2022, my lords, the entire proceedings before the learned trial judge has been stayed. If my lords kindly see the order sheet, my lords.
So COVID was not the reason. How many times you sought filing written statement?
Only two occasions, my lords. 2 occasions.
2 times.
No, that perhaps might not be correct, my lord.
Like,
How
my lords,
many?
if my lords kindly.
Might not be correct, my lord. Not 2 times, my lord, they sought for multiple times.
1 minute.
Because, my lord,
Initially,
So
initially I
you
was.
were appearing in the court and seeking time to file written
My
statement.
lords, initially.
and in the initially, my lord, and in the
I was
interim-
placed ex parte, my lords. Initially, I was placed ex parte. That was set aside by filing an application for setting aside ex parte. After that, 2 occasions only, my lords. On the next occasion, I mentioned to the honorable, filed a memo saying that I am intending to file an application under section 8, what I mentioned before the honorable trial judge, my lords. And even the learned trial judge has recorded that also. During that time, there's settlement talks were also going on between the parties. Since the settlement talks did not fructify.
Is there any arbitration clause?
There is, my lord. There is. Admittedly, there is an arbitration clause, my lord.
There is?
There is.
Please, my
There's
lord,
no
3
dispute
agreements are there. Admittedly, there are.
There is, my lord. I would not come in the way.
Then why didn't you challenge, why didn't you file it at the first instance?
Please, my lords.
Section 8.
Because they come to the court, my lords, they say, I'm intending to file in the month of November 2021. After 6 months, my lords, in March 2022, they file an application, my lords. So around 4 months even gone from the time of intention to the time of filing.
But tell us one thing, when the time was there, whether he could have forfeited the right.
My lords, my submission is, had they challenged the order of forfeiture, my lords, then I would have no legs to stand before this court, my lords. I would have to go to
He
arbitration.
filed an application for recall and before May.
Because that is, my lords, has not been considered by the court. And my lords, that
No,
is where, my
that
lords.
way, in a way, is something he is expressing himself. Look
Yes, my
here,
lords.
what you have done is not correct.
But what has happened is, my lords, had they challenged that particular order, my lords, I wouldn't have law. But my lords, today, without being that being subject matter of challenge, my lords, then this Section 8 order will have to stand, my lords. That is all I have to say, my lords. The order of 30th, the impugned order as of today, stands on a footing, my lords, that they have foreclosed their right to file a written statement, and hence the Section 8 cannot be taken into consideration. That's the stand of the trial court. And that's what the Delhi High Court also has ruled. Now, without challenge to the 24th of March 2022 order, my lords, then this perhaps, my lords, would not be the correct place to challenge that, my lords.
Was Section 8 filed
On the 30th, my lords, on the same day.
when the application for recall was filed?
Yes, no. Recall came much
First
later.
filed, we filed Section 8.
Oh, on the same day.
Yes, my lords. The day the matter was posted for cross-examination, they come up and file a Section 8. The court says, look, you come up at a very later stage, I'm dismissing it. On the next subsequent, that is the 5th of April 2022, they filed recall, my
But
lords.
mind it, even suppose for a moment that 33 was Section 8 should have gone.
Because imagine a situation, in a case, my lords, where
Sometimes I feel, I don't know, what is the finding of the Delhi High Court there? See, it's though a procedural, Section 8 in that sense. But it goes to the root of the root insofar as the maintainability of a suit.
yes, my lords.
To that extent, it becomes a sort of a substantive right in the sense. Because it's a remedy.
Yes, the arbitration clause will be thrown to that. Yes, my lords.
And on 5/4, when he filed the recall application,
No, 5/4, they file an application not to recall, my lords. They file an application to recall. The auditor sought permission to file written statement. They don't come along with the recall application as well as written statement. They say, give us more time, which is fine, my lords, because they have time till 30th of May 2022. But the fact that, my lords,
Recall the order.
and they were within time,
they're within time.
and appellant defendant filed present appeal also against Section 8.
Hence, my lords, without the judicial order of 24th of March being in subject matter of challenge, my lords, that is where, my lords, is the right of. Otherwise, my lords, I would have no case to argue today. The Section 8 will clearly applicable for an arbitration clause.
Your only point is this:
Right to forfeiture has happened.
after forfeiture, 8 comes.
Yes, my
They
lords.
want to circumvent.
That's all, my lords.
That's
all.
what he is arguing. Look here, I'm still within time
Yes.
for filing written statement. And I filed recall also within the
Within time.
outer limit for
30 days.
Yes, my lords. That is my case, my lords.
that also, he says,
It's within time.
so now effectively,
Hence, my lords, I was saying, my lords, had they challenged the 24th of March 2022 order, I would have no legs to stand and pursue my lords to see other way.
effectively, they have challenged.
Regarding that, I filed an application for recalling, my lords.
Not in this
Order
court.
dated 24/3/2022, my lords, my application for recalling is pending before the learned trial judge.
Come again?
My application regarding 24/2, recalling the order of forfeiture, it's been the subject matter in my recalling application pending before the learned trial judge.
Today?
As on today.
As on today's
Their application is still pending, my lord.
Pending?
Yes, my lords, because matter has been stayed. Matter has been stayed by
As
the
on today,
honorable
it is
court.
still pending, my lord, because the matter is stayed by this honorable court. Entire proceedings has been stayed.
Are you happy that if that application would be decided once?
Not
that-
only, my lord, my Section 8 has to be, my lord, yeah.
No, my lords, that is a problem, my lords. Now, today, they take a chance before the court
No,
saying
my
that my Section 8 has been dismissed.
Then why did you file recall?
Yes, my lords.
Why did you file?
My lords, as on today.
And mind it, you filed this recall after your Section 8 was rejected, and you
That's what, oh, no, after filing my section 8 and rejected. Please, my lords.
So then
That
why did-
regarding,
Why did you then file it? Why did you file it?
lords, actually, as
It's like this, you would be, you know, in the sense foregoing your right under arbitration.
And interestingly, my lords,
as on today,
they come to this
as on
court.
today, my lords, my written statement is not on the record of the trial judge.
I know, but that application is there. For recall is
My lords,
there.
right to forfeit is been the, is the subject matter there. Regarding filing of the written statement is not,
What is the application for?
recalling the order dated 24/2/2023 for future.
What is the effect thereof? You will be permitted to bring written statement on it.
Under protest, without prejudice, my lords,
what
my
has also happened
application
is
will be there.
between 30th of March 2022 and 5th of April 2020, my lords, on the 1st of April, they challenged the Section 8 order before this court, my lords, which is what we are adjudicating today. So, my lords, they take a chance. They take a chance everywhere they go. First, the Section 8 gets rejected. They come in the appeal on the very next day, and later on they go and file a recall application, my lords, before the court.
You have any objection on written statement being filed?
I no, my lords, I don't. I am not fighting on technicalities, my lords. If they file a written statement, let them file, my lords.
Not
I'll
that-
contest the order merits.
Why we record? I think your litigation.
Because, my lords, it's also, my lords, 120
That's the
periods.
fairness on his part.
No, because also my 120 days, my lords, have not gone by, my lords, returned till now.
And mind it, that law is first 90 days in any case as a matter of.
Yes, my lords.
For the subsequent period, you have to show the cause, could not file it in the first initial period. That's the point. So you record the statement, you file your written statement.
Section 8, my lords.
Well, want to section 8, then we will.
As on today, my right to file section 8 is not been obliterated. Is my submit.
of settlement between the parties?
Please, my lords.
Any possibility of settling the matter between the parties?
My lords, what has happened? Well, merits of the matter is very simple, my lords. My lords, I was, my lords, providing them services, my lords, to see that their washrooms and other upkeep, my lords.
Housekeeping.
So this is housekeeping, because David was a Goliath battle, my lords. This is a dispute of 6 lakhs. And that's all, my lords. That's all, my lords.
I'll check with
My
my
lords,
clients also.
And during the interim, my
client-
lords, during the interim of this appeal, my lords, we have gone them and told them, please settle, please do something. Don't give us the interest, give us the principal amount. We're more
I'll
than
check
happy.
with my clients.
Now, my lords, they are trying to, my lords, they're paying 1/4 of the principal
How
sum.
much
my
of the
lords.
litigation has gone through only for that?
I will check with my clients also.
So the last
As
time
a
the same thing
council,
happened.
we should have sat together and worked it out.
Please, my lords. I'll
No,
check.
we've been going to their doorstep, my lords, because, my lords, end of the day, we did our services to them. And in 5 lakhs, my lords, I'm let go of principal also, my lord. I don't want my principal also. Just give my principal, I'll be more than happy. In principal, my lord, out of 5, they're asking me, please take 1.5 and close the matter.
We
What
are
do I do?
having it tomorrow. Work it out between both of you and take your construction instruction and settle whatever is the way to settle it out. So much, this was the only.
That's all, my
dispute.
lords.
8
Yes,
lakhs,
yes,
8 lakhs is the matter.
I'm let go.
8 lakhs, their claim is for 8 lakhs.
I'll let go of my principal sum, my lords. I'm let go of my interest sum, my lords. Principal is what I'm claiming, my lords.
Yes, I'll check.
Okay, okay.
Can it be on day after, my lords?
No, sir.
We'll have it, yeah.
No, sir, I am not there, my lords, from tomorrow. May I have on 12th, my lords?
You're not in town.
Yes, I'm not in 12th. 12th, my lords. Let them also decide.
We'll have it tomorrow. Just see that you are here tomorrow.
No, no.
You're not tomorrow, okay. We have heard the counsel for the parties. To enable the counsel for the parties, take instructions, re-notify 12th.
Much obliged.
Okay,
Small matters take a lot.
what is the sum total? We didn't ask you what is the dispute about. We thought there must be some dispute.
Sorry, my lords.
No, it's all right. Now you will
Please.
talk to your respective clients and
My lords, we've been trying to reach out to them, my lords.
teach each other what
Please.
are the settlement.
Please. Please.
Sandeep.
Much obliged.
Next, ma'am. That NHAI. Just call that.
Serial number 14.
Yes, my lord, I appear for the appellant.
Apologize, my lord. Morning, not appear, my lord. I held up in the.
I know he said that. Respond, there is no one.
The rates of the matter, my lord, the counsel on record is unwell, my
You
lord.
appear for whom?
Respond number 1, my lord.
Oh, you appear for.
I'm head up in the other court, my lord, in the morning when the matter is.
So what do you say?
My lord, in the instructions, I have to secure instruction, my lord, in weeks time, my lord, the senior is unwell, my lord, therefore 6 weeks time. Next week, any date, my lord.
You have heard the matter.
Please, ma'am.
We have discharged the board, we have adjourned that matter also. You are the counsel, no?
Well, my senior is, Prithvi Vadir is, I'm the colleague.
When do you want?
Next week, my lord, 10 days, my lord.
Just say next week, man, give any date except Monday.
13.
We have, just say that, we have
Yes.
heard the learner counsel for the appellant. To, at the request of counsel for the respondent number 1, re-notify.
This is a part of matter, ask your.
Please, I'll inform.
14/11.
There is one more matter.
20.
13th for this matter,
Madam,
13th,
No, 14/11, madam.
14/11. Please.
Serial number 20, please, ma'am.
Serial number 20.
I'm appearing for the respondent in this matter, please, ma'am.
I apologize for that, madam. I am coming from the office, madam, so that before I am not able to.
Pardon?
I apologize for that, my lords. I am coming from the office, so I am not able before calling the morning session.
Now you are ready to argue the matter now?
Yes, please.
You ready? Good, go ahead.
This is connected matter that criminal appeal 80 of the 2022.
Yes.
That is that brief facts is that we have filed the application under order 39 rule 1 and 2 of CPC. And the defendants has filed IA regarding section 8 of the Arbitration and Conciliation Act. That IA has been dismissed and IA number 2 has been IA number 3 is allowed, IA number 3 is allowed and IA number 2 is dismissed. We are before this court is that we have, that is commercial appeal 80 of 2022 is that set aside the order passed by the principal session judge passed in the OS number 8 of 2021, that is IA number 3 dismissing of IA number 3.
But there is an arbitration clause.
Yes, my lords.
Then how can you come out of that arbitration clause?
My lords, our contention in the trial court also on before this honorable court also, without knowledge of our client or our party, they took signatures for so many papers while taking the loan. That time he is uneducated, our client is uneducated, so that without knowing that he signed, and that is the contention we have taken in the client also. And now in the grounds, we are taken that Section 8 of the Arbitration and Conciliation Act contending that as the agreement contains arbitration clause such as the plaintiff has not to approach the arbitrator and suit is not maintainable before the civil court. And also, the Arbitration Act clearly provides that for the provision for invoking arbitration clause and appointment of arbitrator, under these circumstances, the trial court have no jurisdiction to refer the matter written to the plaintiff or being presented before the arbitrator. Hence, the trial court has no jurisdiction. Hence, the trial court is without jurisdiction. They had passed an order. And again, we have taken other ground that Section 8 only empowers to enforce only the court authorized under the Arbitration and Conciliation Act. In the instant case, the suit is under the provision of Commercial Court Act also. As such, the court has power only either dismiss the suit as not maintainable or reject the plaint on the ground of alternative remedies. And also, only when the case is pending before the arbitrator and already a person invoked the arbitration clause, then only trial court can ask to withdraw the suit and appear before the arbitrator. And also, there is no arbitration in instant case. There is no arbitration proceedings or pending before the court.
That will be initiated.
Alerts?
That will be initiated. You must initiate.
There is no
Why not? You initiate, you invoke the arbitration clause, proceed. What was your case before the civil court?
Civil court is that.
What was the claim?
Grant permanent injunction by restraining the defendants, their man, agents, and followers and supporters.
Suit was for injunction.
Yes, sir. Yes, my lords. Permanent injunction.
Yeah, then you go ahead. You can still go, file your, invoke the arbitration, seek appointment of arbitrator, and then proceed.
In the trial court.
Not in the high court, before arbitrator.
Before the arbitrator, we have to go to the arbitration.
Yes, you should know you should understand the procedure and then proceed. Okay, we will now close both the appeals.
Okay, my lords.
The challenge in both the appeals is to a common order dated 26 November 2021, whereby the learned principal districts and sessions judge at Davangere has decided two applications, being IA number Roman 2 and Roman 3 in COM OS number 8 of 2021. Stop IA, the appeal being 80 of 22 has been filed challenging the order passed in IA number 2, whereas the appeal 81 of 22 is in IA Roman 3 is Roman 3. Stop. The IA 2 was filed by the appellant herein under Order 39, Rule 1 and 2 CPC, seeking an order of seeking an ad interim order of ex parte temporary injunction, restraining the respondent herein from seizing the suit scheduled vehicles from the custody of the appellant, except under due process of law, till the pendency of the suit. Whereas IA 3 was filed by the respondent herein under Section 8 of the Arbitration and Conciliation Act 1996, seeking an order in view of Article 15 of the loan agreement dated 22/10/2018, that the parties to the suit be referred to arbitration. The learned district judge has dismissed, has allowed IA 3 filed by the respondent herein by holding that the suit is not maintainable and ordered the return of the plaint for referring the matter to arbitration. Whereas, full stop. Consequently, the learned district judge on that said finding, dismiss IA2. IA2 filed by the appellant herein. Good stuff. The case of on the application filed under Section 8 of the Act of 1996, the case of the appellant, the stand of the appellant was that the same is not maintainable. Full stop. All the agreements relied upon by the respondent were created, including the clause of arbitration, and under such circumstances, the application is not maintainable and the dispute could not have been referred to the arbitration, cannot be referred to arbitration. So it was further contended that the suit is only for permanent injunction against the respondents, and the first respondent has not filed the written statement despite taking several opportunities to file the same, and hence the filing of the application is highly belated. Further, it was contended that the suit was filed by the appellant as a commercial original suit as per the Commercial Courts Act, and hence the learned district judge has the jurisdiction to entertain the suit. Full stop. In support of its contention, the learned counsel had relied upon Section 10 of the Commercial Courts Act. Full stop. The learned judge on the application filed under Section 8 of the Act of 1996, as in paragraph 18, 19, and 20 held as under. Full stop. There is no dispute. Nor just say that the counsel appearing for the appellant has conceded the fact that there is an arbitration clause in the agreement. But according to her, since the agreement itself was executed, the agreement, it just said the submission of the learned counsel for the appellant is that the appellant was made to sign blank papers, and in that sense, the agreement having not been executed by the appellant, the arbitration clause shall not be binding. Full stop. We find from the order of the learned single judge or learned district judge, no such plea has been advanced, as no such plea was recorded by the learned district judge. Full stop. The contention as noted above, the contention was primarily that all the agreements relied upon by the respondent were created, including the clause of arbitration. Full stop. Surely the plea advanced before the learned district judge is at variance with the plea now sought to be advanced by the learned counsel for the appellant. Full stop. Having said that, and also noted the fact that the learned counsel for the appellant has not disputed existence of an arbitration clause in the agreement, the necessary consequence must be that the suit, that the subject matter of the suit need to be adjudicated through the process, through arbitral process, and in that regard, the respondent had rightly filed an application under Section 8 of the Act of 1996. Given the aforesaid, given this position, we are of the view that the learned district judge had rightly disposed of IA3 by directing return of the plaint to be filed before the return of the plaint to the appellant for referring the matter to arbitration. Consequently, the rejection of the IA2 being an application under section, under order 39, 1 and 2 CPC was rightly dismissed as the suit itself was not maintainable. First. Accordingly, we are of the view that the present appeals are devoid of merit and the same are dismissed. And that's all, ma'am.
Please.
Huh? There's another one. Abhishek. We just say this, on the last date of hearing, that is on 16/7/2024, this court had directed issuance of court notice to the appellant Abhishek Kumar. Full stop. We have been informed by the court officer that the court notice was not issued to Abhishek Kumar. Hence, we direct issuance of a court notice forthwith to the appellant Abhishek Kumar, returnable on given November only.
28/11.
Okay.
My lords,
We have issued notice in that.
please, my lords. Okay.
To appear for whom?
We are for the respondents, my lord. The inter-se dispute between the parties has been
The
settled.
court notice was not issued, so we have issued a fresh notice.
Please, my lord.